The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to today's hearing on lessons from the Mueller report, presidential obstruction and other crimes. I will now recognize myself for an opening statement. Just over 2 years ago, Special Counsel Robert Mueller was charged with conducting a full and thorough investigation of the Russian government's efforts to interfere in the 2016 presidential election, unquote, including an examination of, quote, any links and or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, and any matters that arose or may arise directly from the investigation, close quote. He concluded in his own words, quote, Russian intelligence officers who were part of the Russian military launched a concerted attack on our political system. Those officers used sophisticated cyber techniques to hack into computers and networks used by the Clinton campaign. They stole private information and then released that information through fake online identities and through the organization WikiLeaks. We now know that the Russian government timed their operation to interfere with our election, to harm the candidacy of Secretary Clinton, and to benefit the Trump campaign. Separately, the special counsel concluded that Russian entities, quote, engaged in a social media operation where Russian citizens posed as Americans in order to interfere in the election, close quote. Using fake identities on social media platforms like Facebook and Twitter, these operatives planned rallies in favor of the president and spread lies about Secretary Clinton made to look like legitimate media. Again, these activities represent a direct attack on our democratic process. With respect to these two specific operations by the Russian government, the special counsel did not find sufficient evidence to charge Trump campaign officials with conspiracy against the United States. He did, however, document at least 171 contacts between members of the Trump campaign and transition team and the Russian government. 16 Trump campaign officials are known to have had direct communications with Russian agents. Representatives of the Trump campaign exchanged emails and phone calls and held face-to-face meetings with high-level Russian government officials, Russian oligarchs, and even some of the hackers the special counsel accused of working to sway the election. There can be no question that Congress must investigate this direct attack on our democratic process. I believe that Ranking Member Collins agrees that we must do so without delay. In a letter he sent last month, he urged the committee to call Robert Mueller to testify during the Memorial Day recess if necessary, both for the sake of transparency and, quote, for the American public to learn the full contours of the special counsel's investigation, close quote. In a letter he sent last week, the ranking member again asked us to examine, quote, the threat Russia and other nefarious actors have played and may continue to play in our elections, close quote. Over the course of the coming weeks, this committee will do just that. We will examine the effects of foreign influence on our elections. I hope that we will hear testimony from the special counsel as well. But the country cannot hope to understand the Russian government's attack on our democratic system if we do not also investigate who stood to benefit from that attack and the extent to which the Trump campaign may have welcomed it. Similarly, we cannot fully understand the special counsel's work without also discussing President Trump's repeated attempts to undermine it. In his report, the special counsel describes 10 separate incidents in which the president attempted to change the scope or direction of the investigation or to end it altogether. At one point, President Trump ordered White House counsel Don McGahn to fire the special counsel. Later, he asked McGahn to write a letter stating that the incident never happened. McGahn said he would rather resign. At different stages, he asked Attorney General Jeff Sessions to unrecuse, in quotes, himself and to step in to direct the investigation away from the president's conduct. And of course, the president's public statements about this investigation before and after the results of the Mueller report are, at best, at odds with the evidence laid out in the report itself. There can be no question that this committee must investigate this behavior as well. Today's hearing is the first in a series of hearings designed to unpack the work of the special counsel and related matters. We have a responsibility to do this work, to follow the facts where they lead, to make recommendations to the whole House as circumstances warrant, and to craft legislation that makes certain no president, Democrat or Republican, can ever act in this way again. Our witnesses today include 3 former federal prosecutors, each of whom has considerable experience weighing the kind of evidence laid out by the special counsel in his report and in his indictments of 34 individuals, including President Trump's national security advisor, his campaign manager, his deputy campaign manager, and his personal attorney. Our panel also includes Mr. John Dean, who served as White House counsel to President Nixon and who became a critical witness for prosecutors and congressional investigators attempting to respond to President Nixon's attempt to obstruct the Department of Justice and the FBI. We will rely on the expertise of these witnesses to help draw our own conclusions about the findings of the special counsel and other evidence before us today. We will do so mindful of the House rules that prevent us from making inappropriate personal references to the President, to members of this committee, and to other members of Congress. But the rules of decorum in the House of Representatives are a shield, not a sword. The rules are designed to focus the debate on the facts and the law, and can therefore help us discuss the findings of the special counsel with the seriousness they deserve. The rules are not, however, an opportunity to avoid discussing serious allegations of misconduct altogether. I know that the ranking member and I disagree on any number of topics, including on what conclusions we should draw from the facts laid out by the special counsel. For example, in his last letter, he argued that President Trump has been, quote, vindicated, unquote, by the special counsel's report. I cannot agree with that conclusion. Neither, I believe, could the special counsel, given his insistence that his report, quote, does not exonerate the president, close quote. But I also know that the ranking member and I agree on the seriousness of the attack on our elections, that we must work together to make it more difficult for any president to ignore the danger that presented itself in 2016. That work continues in this hearing room today, and it continues at the Department of Justice later this afternoon, when this committee will begin to review some of the documents that Attorney General Barr previously denied us. I am pleased that we have reached an agreement to review at least some of the evidence underlying the Mueller report, including interview notes, firsthand accounts of misconduct, and other critical evidence, and that this material will be made available without delay to members of the committee on both sides of the aisle. As a result, I see no need to resort to the criminal contempt statute to enforce our April 19th subpoena, at least for now, so long as the department upholds its end of the bargain. But our arrangement with the department does not extend to the full scope of our request for the full Mueller report and its underlying materials, including grand jury information, nor does it extend to our demand that Don McGahn, a key fact witness, testify before this committee. Our work will therefore continue tomorrow on the House floor when we consider Chairman McGovern's resolution to authorize this committee to enforce its subpoena through civil litigation. It is my expectation that as a result of this authorization, Mr. McGahn will testify before long. And between now and then, we still have an obligation to investigate the deeply troubling evidence outlined by the special counsel. Not merely the portions that implicate Russian nationals, as some have suggested, but the entire report, including the volume that lays out some of the president's troubling behavior. The committee's work is serious. We should delay it no further. We should conduct ourselves in a manner that is consistent with the rules of the House and worthy of this chamber. And even if we cannot agree to draw the same conclusions from the evidence, we should at least proceed with a common understanding. We were attacked. We were attacked by a foreign adversary. President Trump's campaign took full advantage of the attack when it came. The descriptions of obstruction of justice in Volume 2 go to the heart of our legal system. If we can agree on this common set of facts as our starting place and agree to follow the facts and the law where they take us, I believe we can make a great deal of progress in this hearing today. I thank the panel for being here today, and I look forward to your testimony. Before we proceed further, I want to note for the record that the gentle lady from Pennsylvania, Ms. Dean, is unable to be with us today due to a death in the family. She very much wanted to participate in today's hearing, and I did not want anyone to misinterpret her absence. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. And I appreciate especially the last, and I would extend my prayers and thoughts to Ms. Dean as well. I'm just a little under a year. In fact, Monday this week will be 1 year from losing my mother. So it is, for all of us, we go through that, and it's an expression of love. However, I will come to this hearing today and say that we are continuing. I appreciate the chairman's understanding. I appreciate the chairman outlining a great deal of the basic conclusion that was an affirmative conclusion from the Mueller investigation. That was the foreign interference in the Russian part of this. What is amazing, though, and I agree with the chairman's assessment of being attacked, and that's something we've known, the Russians were always a part. For some of us, we've been talking about the Russians for a long time in that, but it's about priorities. And here's my question about priorities and coming to this hearing. And the question of priorities is if we were attacked, as the chairman just said, then the priority should be to go to the battlefield on the attack where we were attacked on and not run by the sideshow to hear from the commentators. We should actually go to the one that Mr. Mueller actually said was, we have a problem here. We're showing you we've actually introduced indictments here. How can we firm up our elections? How can we do away with foreign interference? How can we do that? It's about priorities. And I think what has happened here is the chairman is showing the priorities. The priorities were from November 2016, it appears that we have an issue with who got elected president. And we thought the Mueller investigation would solve this for us, and it really did not, even after a lot of discussion. We're going to hear a lot about that today and the discussion that we have. But it goes back to priorities, and priorities of bringing what we focus on and how we focus on it. And if you look at the witnesses today and you discuss what was actually just went on for a while, we're not bringing Russia front and center. We're not bringing the threats to our election front and center, although I appreciate the chairman reading the letters that I send him and understanding what we could actually be working on. And I'm wanting to move forward there. But however, here we come with some folks that are great folks. You're wonderful on TV. I could catch your testimony on TV. In fact, by the way, I could this morning. I'm a Republican. I believe that you use everything that you've got to as much business as you want and generate as much as you want to work for yourself. But I don't believe it's the problem of this committee to have to come and hear from those who are not a part of the Mueller investigation, who are not a part of this, pontificating on things that you can do on TV like all of us get a chance to do occasionally, but not here on the hearing. But then we get, and I'm sort of reminded of the Russia priority issue because just a few years ago it was brought up and one of our candidates talked about Russia being a threat, and the former president, Mr. Obama, said, that the 80s are asking for their foreign policy back. Well, guess what? This committee is now hearing from the 70s, and they want their star witness back. In fact, it's very difficult for one of the witnesses here today, for many of us who could actually trace the distrust in government back to the witness here today, the 70 star of obstruction. In fact, I'll take it a little bit further. For those of us who've been looking into this for a while and wondering how we got started here, and for those of us who've heard me discuss the fact, and many on our committee and on our side discuss the fact of the corrupt cabal, what we see of Strzok, Page, McCabe, Comey, and others, how we actually got started here, I believe that they have the Godfather here today, Mr. Dean. In fact, they probably had a picture of how do we actually use the governmental resources to interfere in other people's campaigns. Mr. Dean is the Godfather. They may even had a picture of you, knowing how you do it. And that is here today, again, to talk about a president that obviously you don't like, an interview in ways that you had pled guilty to. I appreciate your right to be here, and I appreciate your right to share it anywhere else, but don't appreciate the fact that here we are again with priorities in this committee turned upside down. It is interesting to me, and I applaud the chairman for finally getting accommodation process from the Department of Justice that he could have had a long time ago. I'm glad we got it there. Now maybe we can move forward. Maybe we can begin to put this committee in order. But I would just go back and just say that I would ask my chairman on who we do agree on some things. Hopefully tomorrow we're actually going to have a bill we agree on, the 9/11 bill. But while we continue this part, asking opinions from commentators, promoting their agendas, my question is this. At the end of the day, for these not here, they're here commenting on a report. I go back to what the chairman asked, and he said, well, we may get there. And I said, it was, we hope, I think was the exact words just a moment ago, to have Robert Mueller. Hope. This committee is obsessed with a document in which they could talk to the author, and we seem to not want to go there. We're hot and heavy to get everybody else here, but we don't want to go there. Because at the end of the day, the Mueller document, even despite his standing up and statements, stated there was no collusion, which is where it started. Where it started, there was that contact, and there was no charged obstruction. But here we are again today. Here we are looking at it as we go forward. Why? Because there is an obsession. There's another election around the corner. And that other election is simply being played out here. How can we damage the president? Because we don't like the cards that we got to run for re-election on with the economy and other things happening. So, Mr. Chairman, we're here again. I believe the priorities are wrong, but you've called the priorities. So now let the show begin. I yield back.
Thank you, Mr. Collins. I will now introduce today's witnesses. John Dean was the White House counsel under President Richard Nixon. He is most well known for his role as a principal witness during the Senate Watergate hearings, where his testimony was later fully corroborated as to its truthfulness by the revelations in President Nixon's White House tapes. Prior to his time in the White House, Mr. Dean served as the Republican chief counsel of this committee, as well as the associate director of the National Commission on Reform of Federal Criminal Laws. He has a BA from the College of Worcester, and he received his JD from the Georgetown University Law Center. Joyce White Vance served as the U.S. Attorney for the Northern District of Alabama from 2009 to 2017. She also served on the Attorney General's Advisory Committee and was the co-chair of its Criminal Practice Subcommittee. She is currently a distinguished professor of the practice of law at the University of Alabama School of Law. Ms. Vance received her bachelor's degree from Bates College and a JD from the University of Virginia Law School. John Malcolm is the Vice President for the Institute for Constitutional Government and Director of the Meese Center for Legal and Judicial Studies at the Heritage Foundation. He also serves as Chairman of the Federalist Society's Criminal Law Practice Group. From 2001 to 2004, Mr. Malcolm served as a Deputy Assistant Attorney General in the Department of Justice. He received his bachelor's degree from Columbia College, my alma mater, and a JD from Harvard Law School. Barbara McCade served as the U.S. Attorney for the Eastern District of Michigan from 2010 to 2017. She also served as Vice Chair of the Attorney General's Advisory Committee and co-chaired its Terrorism and National Security subcommittees. She is currently a professor from practice at the University of Michigan Law School. Ms. McQuaid received her bachelor's degree from the University of Michigan and her JD at the University of Michigan Law School. We welcome our distinguished witnesses, and we thank you for participating in today's hearing. Now, if you would please rise, I will begin by swearing you in. You raise your right hands. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show that the witnesses answered in the affirmative. Thank you, and you please be seated. Please note that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. I will be a little loose in interpreting that 5 minutes for the witnesses, not necessarily for the members. Mr. Dean, you may begin.
Chairman Nadler, excuse me, Ranking Member Collins. The last time I appeared before your committee was July 11, 1974, during the impeachment inquiry of Richard Nixon. Clearly, I'm not here today as a fact witness. I accepted the invitation to come here today because I hope I can give a little historical perspective on the Mueller report. In many ways, the Mueller report is to President Trump what the so-called Watergate Roadmap, officially titled the Grand Jury Report and Recommendation Concerning Transmission of Evidence to the House of Representatives, was to President Richard Nixon. Stated a little differently, Special Counsel Mueller has provided this committee with a roadmap. Drawing from my testimony, I'd like to offer a few, actually just one I'm going to focus on, parallels I find with the Mueller report. I've laid out in my prepared statement 6 examples. Those examples are illustrative rather than exhaustive. But let me turn to the 6th, and anybody who has any question about the prior 5, I'm happy to address. The 6th is the Mueller report's effort regarding the influence of witnesses with pardons. As the citation shows, it's spread out throughout the report. Mr. Mueller addresses the question of whether President Trump dangled pardons or offered favorable treatment to Michael Cohen, Paul Manafort, Michael Cohen, and Roger Stone, whose name is actually redacted, but based on educated conjecture, I think that's pretty clear who it is. And the question is whether in return for their pardons, they agreed to, or the suggestion of a pardon, he was seeking them to keep their silence, and how they coordinated with investigators. But also the Mueller report offers a very powerful legal analysis that, notwithstanding the fact that the pardon power is one of the most unrestricted presidential powers, it cannot be used for improper purposes. And I give the cite of that argument. What's interesting is Richard Nixon, who used the pardon in a similar way, recognized that it was improper. For example, in December of 1972, Chuck Colson went in to see the president to get a pardon, a commitment for Howard Hunt, who he had been responsible in bringing into the White House and whose wife had recently died in a crash and felt he couldn't withstand a trial and didn't want to spend the rest of his life in jail, so he was seeking a pardon assurance from Chuck Colson. The president reluctantly agreed to do that. And when Hunt was given the word, the so-called Cuban Americans who were part of the Watergate operation, they also took their cue from Hunt and pled. In my March 21st conversation with Nixon, we got into the subjects of pardons, and he at that point said he very clearly understood to grant pardons it would be wrong. I cite the actual exchange from that conversation. There's one that I did not cite in here is, I learned in a later tape that Ehrlichman had been asked by the president to offer me a pardon to protect me and hopefully encourage me from not breaking rank. Ehrlichman knew that was wrong, so he didn't offer that pardon. In one of my last conversations with Richard Nixon, he told me in a very peculiar manner, getting up from his desk in the EOB office and going across the office and in a stage whisper saying to me, "John, I made a mistake in talking to Colson about clemency for Hunt, didn't I?" And I said, "Yes, Mr. President, that was probably obstruction of justice." When Haldeman and Ehrlichman were departing, they pled with the White House that they be given pardons. I think because Nixon knew he could only compound his situation at that point, that he refused to even entertain the request. Finally, let me close on the note, and I explain this at some length, that I certainly hope Don McGahn is a key witness before this committee. Because of my testimony, the model code of the ABA today makes very clear in Rule 1.13 that Mr. McGahn represents not Donald Trump, but the office of the president. His client is the office of the president, and I think he owes that office his testimony before this committee. Thank you.
Thank you, Professor Vance.
Good afternoon, Chairman Nadler, Ranking Member Collins, and members of the committee. Oh, am I not in it?
Press the little button, too.
Better? I'll start over. Good afternoon, Chairman Nadler, Ranking Member Collins, and members of the committee. Thank you for calling this hearing and for giving me the opportunity to testify and answer your questions. Let me cut right to the chase because I am a law professor, and so I'll start with some basic legal context. The federal principles of prosecution direct prosecutors to indict a case only if they believe they can obtain and sustain a conviction. That means obtain a conviction at trial, sustain it on appeal. The Mueller report sets out the 3 elements prosecutors have to be able to prove for each charge of obstruction of justice they would potentially bring: an obstructive act, a nexus between that act and an official proceeding, and a corrupt intent. So those are the 3 elements prosecutors would have to be able to prove beyond a reasonable doubt at trial. Because the special counsel followed DOJ policy and guidance in memos issued by the Office of Legal Counsel that prohibit indicting a sitting president, the report analyzed the evidence it contained without making an ultimate decision as to whether the evidence was sufficient to indict. Now, people can debate the merits of that position that's taken by the Office of Legal Counsel in the memo, but as long as that memo is in effect, it binds DOJ lawyers, and Robert Mueller, in his consideration, committed to following the law. I've reviewed Volume 2 of the Special Counsel's report, which lays out the evidence collected while investigating 10 potential instances of obstruction of justice. And based on my years of experience as a prosecutor, if I was assessing that evidence as to a person other than a sitting president who's covered by the OLC memo, the facts contained in that report would be sufficient to prove all of the elements necessary to charge multiple counts of obstruction of justice. The evidence is not equivocal, nor is the charging decision a close call. And I would be willing to personally indict the case and to try the case. I would have confidence that the evidence would be sufficient to obtain a guilty verdict and to win on appeal. Here's what I see as a prosecutor reading this report. There was an attack by a foreign country on our country and on our elections, and on multiple occasions the president tried to thwart it, curtail it, or end it completely, either by removing Mueller outright or by interfering with his ability to gather evidence. Here are some examples of the president's behavior documented by witness testimony and evidence collected by the special counsel. In the middle of the investigation, the president ordered his White House counsel to fire the special counsel. When that effort to fire the counsel became the subject of news reports, the president asked his White House counsel to lie about it and to create a false record to back up the lie. When the White House counsel declined to carry out his orders, the president moved outside of government, asking his former campaign manager to get the attorney general to unrecuse and to restrict the investigation to interference in future elections. In other words, no investigation into the president's conduct, the conduct of his associates, or the conduct of Russia in attacking our elections. When the president's campaign manager refused to carry out this order, the president began to pressure the attorney general personally, telling him in the Oval Office that he would be a hero if he unrecused himself, and making clear at the same time that he would be fired if he didn't carry out the president's demands. And he was ultimately fired. The president pressured multiple aides, including General Flynn, Manafort, and Cohen, not to cooperate with the investigation. He dangled the possibility of pardons if they didn't cooperate with the investigation. The president's personal counsel told his former campaign manager, Manafort, that he would be taken care of if he sat tight and refused to cooperate. This is some of what I see in the report. Based on my experience of more than 25 years as a federal prosecutor, I support the conclusion that more than 1,000 of my former colleagues came to, and that I co-signed in a public statement last month, saying that if anyone other than a president of the United States committed this conduct, he would be under indictment today for multiple acts of obstruction of justice. The Mueller report has an extensive discussion, a layout, a legal analysis about why a president is not above the law. This theory that we've discussed about a unitary executive and the scope of presidential power. But you don't have to be a legal expert to understand that in this country, no one is above the law. If you or I had committed this same conduct, we would have been charged by now. So the task before this committee in Congress is not an easy one. It doesn't bring me any pleasure to have to discuss these facts. I suspect it does not bring you pleasure to have to consider them, but I am honored and sobered to have this opportunity to contribute to your work, and I hope I can be helpful in answering any questions that you have. Thank you very much, Mr. Chairman.
Thank you. Mr. Malcolm?
Chairman Nadler, Ranking Member Collins, and distinguished members of Congress. I'm the Vice President of the Institute for Constitutional Government at the Heritage Foundation. I've also served as a Deputy Assistant Attorney General, an Assistant United States Attorney, an Associate Independent Counsel, and as a criminal defense attorney. Special Counsel Mueller deserves a lot of credit for conducting a thorough investigation. While Volume 1 of his report chronicles in detail how the Russians attempted to interfere in our election and concludes that no one in the Trump campaign was involved in that unlawful effort, I am less enthusiastic about Volume 2. Under the applicable regulations, it was the special counsel's duty to provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by him. By not making a traditional prosecutorial judgment with respect to the obstruction of justice allegations, Mr. Mueller failed to fulfill that duty. While governing OLC opinions provide that a sitting president cannot be indicted, there was nothing to preclude the special counsel from stating that the evidence would be sufficient to convict the president of obstruction of justice if that's what he believed. By not doing so, the special counsel put the Attorney General in the difficult situation of having to make that decision. Here, General Barr's determination that the evidence is insufficient to establish that the president attempted to obstruct justice is eminently reasonable. While it is possible for someone to obstruct justice who did not commit the offense that is under investigation, it is extremely rare. In the overwhelming majority of cases, individuals who attempt to obstruct justice do so because they know darn well that they committed a crime and fear that the investigation will uncover that fact. Moreover, it is almost invariably the case that someone attempting to obstruct an investigation also engages in other nefarious activities, such as destroying evidence, suborning perjury, bribing witnesses, or threatening them with bodily harm. Here, the president provided over 1 million pages of documents, allowed key members of his staff to be interviewed, and submitted written answers to questions. These are not the actions of someone attempting to obstruct an ongoing investigation, despite being clearly maddened by its existence. In obstruction of justice cases, the most difficult thing to establish is that the accused acted with a corrupt intent, that is, for an illegitimate purpose. When someone destroys evidence or threatens witnesses, this task is relatively straightforward. Not so here. The president had perfectly legitimate reasons to be exasperated by the cloud hanging over his presidency from this investigation and for wishing it to come to a speedy conclusion. The investigation caused some to question the legitimacy of his election because the allegations involved claims that high-level people in his campaign engaged in a conspiracy with Russia to steal the election. The president repeatedly expressed concerns that the investigation was hampering his ability to govern and to engage in foreign relations, especially with Russia. President Trump might well have concluded that the investigation should be curtailed or even terminated because it was impeding his ability to do the job that the American people elected him to do. Such an alternative, non-corrupt motive, rather than naked self-interest, might also explain his conduct. Further, adopting Mueller's legal theory could have a chilling effect on a president who might well hesitate before engaging in some controversial action, such as removing an official, signing an executive order, or issuing a pardon, out of fear that his subjective intent might be questioned at some point in the future by a prosecutor, perhaps a politically motivated one, undertaking a criminal investigation. For this reason, the law requires that Congress issue a clear statement before a generally worded statute, such as the one that Mr. Mueller relied upon, can be applied to the president. No such clear statement exists here. To be sure, OLC has stated that some statutes, such as the bribery statute, can be applied to the president. However, while it is easy to disentangle facially criminal acts, such as paying a bribe or threatening a witness, from legitimate exercises of presidential authority, The same cannot be said of many of the acts that were investigated by the special counsel, such as criticizing the fairness of the investigation, asking subordinates to publicly defend him, removing an official, or contemplating issuing a pardon, each of which may have been undertaken for a mixed motive or an entirely pure one. Deciding which is which would inevitably interfere with the president's ability to serve the nation as he sees fit in the exercise of his Article II powers, thereby raising profound separation of powers issues. While it is certainly true that no man, including the President of the United States, is above the law, it is equally true that the President occupies a unique position in our constitutional structure, and that some laws apply differently to him and some don't apply at all, at least when there has been no clear statement by Congress that the law should apply to him, or when doing so might impinge upon the exercise of his constitutional prerogatives. I thank you for inviting me here to testify today, and I look forward to answering any questions you might have.
Thank you very much, Professor McQuaid.
Thank you, Chairman Nadler, Ranking Member Collins, and distinguished members of this committee. I am honored to be here today, and thank you for the opportunity to talk with you about obstruction of justice. I've read the special counsel's report, and to me, the most significant finding in that report is that Russia interfered with our election in sweeping and systematic fashion. And through that lens, I will share two observations. First, about what happened, and second, about why that matters. First, the conduct described in the report constitutes multiple crimes of obstruction of justice. It's supported by evidence of guilt beyond a reasonable doubt, and I'm confident that if anyone other than a sitting president committed this conduct, that person would be charged with crimes. Second, why does that matter? Well, the obstruction described in the report created a risk to our national security. It was designed to prevent investigators from learning all of the facts about an attack on our country by a hostile foreign adversary. Let me explain each of those observations briefly. First, what happened? The special counsel's report describes 10 episodes of potential obstruction of justice. And with regard to 4 of those episodes, the special counsel found substantial evidence for all 3 elements of obstruction of justice. Those obstruction crimes include requesting that White House counsel Don McGahn remove Robert Mueller as special counsel, asking Don McGahn to falsely deny public reports about that order and to create a false document to support that lie. It includes reports of efforts to persuade Attorney General Jeff Sessions to reverse his recusal decision, which would have been unethical, and to publicly announce that the Russia investigation would focus on future elections only. It also talks about efforts to influence the testimony of Paul Manafort, a former campaign chairman. Let me focus on just one of those incidents, and that's the incident where the report describes persistent efforts to curtail the special counsel's investigation by directing Attorney General Sessions to reverse his recusal decision and to limit the investigation to future elections. President Trump asked various intermediaries, including Corey Lewandowski, who was at that point a private citizen, to convey a message to Mr. Sessions, but ultimately none of them did it. But for the acts of those associates, Mr. Trump would have limited the investigation to future elections. That would have prevented Mr. Mueller from learning the facts about Russian interference in the 2016 election, essential to our national security. And although Mr. Mueller's investigation did not establish the crime of conspiracy against the Trump campaign under federal statutes, proof of underlying crime is not required to prove obstruction. And there's a very important reason for that. That's because it's the interference in the quest for the truth that the law prohibits. And let's not forget that the investigation did establish sufficient facts to charge 37 defendants with crimes, including Russian intelligence officials. And that's despite the fact that some people, including the president, refused to talk to Mr. Mueller. The report says that some people lied to the special counsel, some deleted communications, and some used encrypted applications to conceal their conversations. As the report says, given these gaps, the office cannot rule out the possibility that unavailable information would shed additional light. This body has the power to obtain additional information. The report identified possible motives, including personal embarrassment, the possibility that his conduct amounted to crimes, and the legitimacy of his election. And second, why it matters. If Mr. Trump had been successful in limiting the scope of the investigation to future elections, that would have harmed our national security by shielding Russia's conduct in attacking the 2016 election. But for the conduct of other individuals, Mr. Trump would have thwarted Mr. Mueller's efforts. By seeking to curtail the investigation, President Trump committed an act that threatened the national security of this country. As Robert Mueller concluded in his report, he reiterated that the central allegation of our indictments were that multiple and systematic efforts to interfere with our election occurred. That allegation deserves the attention of every American. I hope to answer your questions to give that allegation the attention that it deserves. Thank you.
Thank you very much. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Mr. Dean, as you're no doubt aware, the committee subpoenaed former White House counsel Don McGahn to produce White House documents shared with him and his counsel over the course of the special counsel's investigation and to testify before the committee on May 21st. At the direction of the White House, Mr. McGahn has not produced any documents. Additionally, the White House, while it has not formally invoked executive privilege over any specific information Mr. McGahn's testimony may cover, has nonetheless instructed him not to appear at all merely because it may implicate the privilege. Do you agree with the White House, or does Mr. McGahn still have a legal obligation to appear before the committee? And if so, why?
I have also read the OLC opinion of May 20th that says that a White House employee or a former White House employee has total immunity from testifying or appearing before Congress. That pushes the outer limit further than I have ever seen it pushed. And while they cite me in that memo, for 2 memos I received, both of those instances, the witness did appear. The Flanagan memo, for example, it was arranged that he would come to Congress. In other instances, when Henry Kissinger was asked to appear, we found a middle ground to have a meeting in Blair House. So there are solutions to this if the parties want to cooperate. So I think this is a smokescreen at this point, and I hope that the committee will pierce it because I think it's important.
Thank you. Professor McQuaid, on page 1 of volume 2 of the Mueller report, the special counsel described the legal and policy considerations that guided his investigation. The special counsel begins by noting that his team determined not to make a traditional prosecutorial judgment and that his office accepted the Department of Justice OLC conclusion, which states that an indictment of a sitting president would, quote, impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions, close quote. The special counsel, however, made clear as well that a federal indictment of a sitting president would also potentially preempt constitutional processes for addressing presidential misconduct and specifically referenced Article 1, Congress's Article 1 powers. What do you make of Special Counsel Mueller's reference here to Congress's separate authority?
I think that what Mr. Mueller was doing there was being incredibly deferential because he was bound by the Office of Legal Counsel opinion that said he could not indict a sitting president. He thought it would be improper to even make an accusation that would disparage President Trump because he did not want to step on the powers of Congress, which alone has the power of impeachment.
So do you agree that with the special counsel that Congress has an independent duty to investigate possible misconduct or malfeasance by executive branch officials, including the president, even if that's a do-over of the Mueller report?
Yes, I do, and I don't know that I would even call it a do-over. I think it's a separate inquiry that this body has a responsibility to conduct.
Thank you. Now, returning to the Mueller report, the special counsel specifically notes that he pursued his obstruction of justice investigation in order to preserve evidence and protect the integrity of future investigations. The special counsel's report states, quote, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognizes that a criminal investigation during the president's term is permissible. The OLC opinion also recognizes that a president does not have immunity after he leaves office. And if individuals other than the president committed an obstruction offense, they may be prosecuted at this time. Given those considerations, the facts known to us and the strong public interest in safeguarding the integrity of the criminal justice system, We conducted a thorough factual investigation in order to preserve the evidence when memories were fresh and documentary materials were available." Close quote. Now, Ms. Vance, Professor Vance, what is your reaction to the special counsel's inclusion of this language in the report?
This language, I think, explains what we all know to be true. There has been a little bit of complaint that Special Counsel Mueller, once he realized he couldn't indict a sitting president, should not have continued to investigate. This language indicates that that's not the case. It was important to investigate while memories were fresh and evidence could be obtained. And that's because a president is not immune for all time from prosecution, only while he's in office. So Mueller could have been investigating for future prosecutors when the president was no longer in office. He could have been investigating information about other people other than the president who might have participated in crimes. There were abundant reasons for this investigation to continue, this investigation into the criminal justice implications of the president's conduct.
Thank you. Finally, Ms. McQuaid, the Mueller report also acknowledges that Congress has the authority to prohibit a president's corrupt use of his authority in order to protect the integrity of the administration of justice. The special counsel further observed that under applicable Supreme Court precedent, the Constitution does not categorically and permanently immunize a president for obstructing justice through the use of his Article II powers. The separation of powers doctrine authorizes Congress to protect official proceedings, including those of courts and grand juries, from corrupt, obstructive acts, regardless of their source, unquote. As such, the special counsel concluded that, quote, Congress may apply the obstruction laws to the president's corrupt exercise of the powers of office. Congress may apply the obstruction laws to the president's corrupt exercise of the powers of office, accords with our constitutional system of checks and balances and the principle that no person is above the law. Do you agree with the special counsel's conclusion that the Constitution permits Congress to prohibit a president's corrupt exercise of the powers of his or her office, and if so, why?
Yes, Chairman. There is an extensive section in Robert Mueller's report that talks about that. It addresses that theory that was first advanced by William Barr in the 19-page memo that he submitted to Congress last summer, taking the view that Congress cannot limit the president because of separation of powers. But I think the ultimate conclusion is that the president does not have just the power to execute the laws, but the Constitution requires that he faithfully execute the laws. And that means that he cannot act corruptly. He must always act in the best interest of the country. And so, yes, I do agree on that theory.
Thank you. My time has expired. I'll now recognize the ranking member, the gentleman from Georgia, Mr. Collins.
Thank you, Mr. Chairman. Interesting last comment there. We may get back to that as this issue of faithful and how that actually turns out. But I do want to go back to something that you and Ms. Professor Vance have both talked about, and it's this issue of did Mueller investigation, did they were going to charge or not charge based on OLC opinion. It's an interesting concept, especially when you go back to not was the final charge from Mueller, but then to Bill Barr himself when actually giving the report the ultimate charging authority here. And it said in the letter, the first letter that came from the Attorney General, it said, after reviewing the special counsel's final report on these issues, consulting with department officials, including Office of Legal Counsel, and applying the principles of federal prosecution that guide our charging decision, the Deputy Attorney General Rod Rosenstein and I have concluded that the evidence developed during the special counsel investigation is not sufficient to establish that the president committed an obstruction of justice offense. Our determination was made without regard to or based upon any limitations based on these considerations surrounding the indictment. Interesting, this has been discussed later on because it became after the discussion, there was a joint statement put out by the Attorney General's office and by the special counsel office that said this. The Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying that but for the OLC opinion, he would have found the president obstructed justice. The special counsel's report and his statement today made clear that the office concluded that it would not reach a determination one way or the other about whether the president committed a crime. And there's no conflict between these statements. So I think the interesting part that is coming along here is this discussion on the fact that it does appear, and you can take one part saying he was bound by this and you can go on that, but the Attorney General made it very clear that when he looked at it and it was up to him if he wanted to move forward with charge, he chose not to charge because Mueller had gave it to him and took into account the special counsel determination, and then later on with the special counsel himself saying that he wasn't going to charge either way and was not bound by this opinion. My question becomes, though, you've got great opinions, both of you, on these issues of obstruction. But again, as I said before in starting this, the main priority, and you both mentioned this, was the Russian interference in our elections. Ms. McQuaid, I have a quote, and it was a tweet from you. It says, "Hey, Mueller, look over here. @Maddow has found the collusion. Follow the sanctions. If this whole cable news thing doesn't work out for you, Rachel, you have a real future in the FBI." This was December 1, 2018. I have a question. Do you, yes or no, do you and Rachel Maddow have evidence of collusion that the special counsel didn't have?
Well, you know, collusion is an interesting term, Mr. Congressman Collins, and it's a term that Robert Mueller in his report says I didn't use because it's kind of confusing. And so ultimately, after reading his report, what he says is, I wasn't able to establish the crime of conspiracy, but he did document numerous contacts between Russia and the Trump campaign. In fact, right at the very beginning of the report, at page 1.
And Ms. McCabe, I want to jump in here because I agree, you can read the report. The interesting, you just made an interesting comment, though, in which many of us have said about this issue of collusion, which there was not. But I've had many, even members of Congress and others, continue this private, that there is collusion in plain sight. The president's committed a crime. And when you just stated the original process here, but my question is, and I'm assuming it's a no, you don't have any more information or evidence than we have here. John Dean, just to...
I'm sorry, is that a question? May I answer?
No, that was... Got a minute and 57. I'm bound by the 5 minute.
I'll refer to page 1 of the report.
And I've read it. Mr. Dean, interesting. You talked about the issue of pardon, but actually in the Mueller report itself, when it talked about the pardon, and you discussed it where Nixon said he shouldn't have, the actual quote on page 122 of this was, "I don't want to talk about pardons for Flynn yet." In fact, the president actually said, he never offered a pardon. He didn't want to talk about it. So again, here's our issue here, and you made the best of all the concerning of this right now. When you start off saying, "I'm not a fact witness." Neither are others. We're simply here conjecturing opinions in law school, and for those of us writing notes feverishly, I feel like, Professor, we're back in law school again. But at the end of the day, where we're headed with this is the concern that I have is that we have, going back, and the discussion was here for later on, what does this committee have that Robert Mueller didn't have? What does this committee have when you go through the literally 19 lawyers, 40 FBI agents, 2,800 subpoenas, 500, we barely can get through most of our work week without stopping up. So I think the question and concern for most of us here is, this is not a redo, as the chairman, it is a redo from a weaker position, and simply goes back to what has always been said here. This is a political consideration, not a criminal. We're not an investigator. There's plenty more that I would like to have answered here. We just unfortunately are bound by our times on this, and with that, I'll have to yield back to the chairman.
Mr. Chairman, may I?
The time has expired. The witness may answer the question.
Yeah, the question was addressed to me, and I think that this committee does have a role, and it is adding something that the special counsel could not, and that's public education. This report has not been widely read in the United States. It's not even been widely read in the Congress from some of my conversations. But I think it's a very important function that the committee is serving by bringing these matters to public attention.
I appreciate that, and for the educational purposes, I really meant it more as a statement and not a question.
The gentleman's time has now expired. The gentlelady from California, Ms. Lofgren, is recognized for 5 minutes.
Thank you, Mr. Chairman. On May 17, 2017, Deputy Attorney General Rosenstein appointed the special counsel, and on page 8 of Volume 2 of the report, it states, and I quote, "In the days following the special counsel's appointment, the president repeatedly told advisors, including Priebus, Bannon, and McGahn, that special counsel Mueller had conflicts of interest." On page 81, the report states, and again I quote, "Bannon recalled telling the president that the reported conflicts were ridiculous and that none of them was real or could come close to justifying precluding Mueller from serving as special counsel." On May 23rd, the Justice Department cleared the special counsel of any conflicts. On page 81 of Volume 2, it describes the president's reaction, quote, "The president complained about the asserted conflicts and prodded McGahn to reach out to Rosenstein about the issue. McGahn said he responded that he could not make such a call, and the president should instead consult his personal lawyer because it was not a White House issue. Mr. Dean, you recall that you were here last, July 11th, 1974. I was here, too, working for my predecessor, Don Edwards, who was a member of the judiciary at this time. You have extensive experience as the counsel for the White House. Understanding the role of White House counsel, why would McCann refer the president to private counsel?
Because what's happened since my day in the White House is the American Bar Association developed a rule, Rule 1.13, which makes it very clear in representation of an organization that the client are not the constituents of the organization or the person who runs the organization or people who run the organization. It is the organization. As a result, Mr. McCann represents not Donald Trump, but he represents the office of the president. So he has a very different client. He also, apparently from press reports, has advised the president that he has no attorney-client privilege. So that's why I would assume is the reason he referred the president to outside counsel to deal with these issues.
Thank you. The report goes on to cite contemporaneous notes taken by Mr. McGahn on May 23rd on pages 81 and 82 of Volume 2. It says, quote, McGahn advised that the president could discuss the issue with his personal attorney, but it would look like still trying to meddle in the investigation, and knocking out Mueller would be another fact used to claim obstruction of justice. Professor Vance, what is your reaction to this exchange between the president and the White House counsel?
This entire set of facts, Congresswoman, is very troubling because remember where we are at this point in time. We have a special counsel who's just been appointed to investigate Russian interference with the election, and now suddenly we have a president who's looking for reasons to remove him. And the reason that the president lands on is, well, this special counsel has some conflicts. He shouldn't be permitted to run an investigation into me. He engaged in some representation with some other lawyers who represented me. We once had a squabble about a golf course. There were a couple of issues that the president raised. And those issues were examined by the Justice Department, and the Justice Department cleared Special Counsel Mueller. So there has never been legally a conflict with Special Counsel Mueller's participation in this case. But the president persisted here, and as you've discussed with Mr. Dean, that was referred on to the president as a matter he should take up with his personal lawyer, not to continue discussing with the White House counsel. And this repeated fallback to the president by the notion that he should be able to somehow conflict the special counsel out of his job was receiving strong pushback. So the president's continued persistence here, at least in my judgment, forms one of the acts of obstruction, ultimately resulting in the president taking affirmative steps to have special counsel Mueller fired. But this entire colloquy that you refer to is very instructive on the issue of the president's intent at this point in time.
Thank you, Professor. Professor McQuaid, do you see it similarly? What's your reaction to this?
It is, and I think one of the things that's important, I know the report is long at 448 pages, but it really is important to read the whole report, and I would urge everyone here to do so if they have not yet had an opportunity, and members of the public, because even though only a handful of the obstructive acts were found to have met each and every element of obstruction of justice, I think it's really important to see the whole context of behavior to understand the significance of those events. If this were a criminal case in court, a jury would be instructed to look at the totality of the circumstances so that they can have a full understanding of what's going on. And it seemed that what's going on here, looking at the totality of the circumstances, is that President Trump felt threatened by Robert Mueller. He felt threatened by him even though there was no ultimate finding of a crime of conspiracy. At the time the investigation was going on, President Trump didn't know that was going to be the outcome. In fact, he was aware of numerous contacts with Russia that may be exposed, the Trump Tower meeting with Russians and his family members. There was also the matter of Michael Cohen's payments to a woman to buy her silence before the election. All of those things could have been things that motivated President Trump. Let's not forget that one of the things that motivated Bill Clinton was covering up an extramarital affair. And so there are things other than the crime that the investigator is looking at that could motivate a person to try to end an investigation. And under the law, they are equally prohibited.
My time has expired.
Thank you, gentlelady. The gentleman from Ohio, Mr. Shabbat.
Thank you, Mr. Chairman. Mr. Dean, it's, to the best of my knowledge, I don't think that we've ever met. I'm one of 435 members of the House. There are a lot of us, but only one of you, and you're pretty famous. Let me take you back a ways. Back in 1972, I was a freshman in college, and I voted for the president for the first time. I'd have been 19 years old. I voted for Richard Nixon, principally because I thought he was improving relations with Russia and with China, and I thought that was a good thing. Well, the next year, 1973, in June 22nd to be exact, I married my high school sweetheart. Next week, we'll have been married 46 years now. And on our honeymoon in Gatlinburg, Tennessee, and then in Mammoth Cave, Kentucky, among other things that I remember watching you testify before Congress about the president that I had voted for and about some very bad things that he had done. The next year, of course, that president resigned in disgrace and was replaced by Gerald Ford. A lot of my friends, people my age at the time, were really turned off from politics, thought they were a bunch of crooks. Why would anybody ever want to be involved in politics? It had just the opposite effect on me. I thought we needed people involved in politics for the right reason, that want to help their community or the country. And so I decided that someday I was going to get involved in politics. And I voted for, a couple years later, 76, I voted for Jimmy Carter, by the way, for president, because I thought it was wrong that Ford had pardoned Nixon, figuring that there'd been some sort of crooked deal that went on there. So anyway, a couple years later, I did get involved in politics, and I ran as an independent for Cincinnati City Council. I lost. Then 2 years later, I ran as a Republican, and this time I lost again. So finally, I did get elected to council the next time, served for 5 years there, served for 5 years as a county commission, and then lo and behold, back in 1994, in the Republican Revolution, I got elected to Congress and got appointed to this committee that I wanted to be on. So 25 years after watching you on television relative to Nixon and Watergate, I was a member of the Judiciary Committee impeaching another president, this time William Jefferson Clinton, and I'm one of only two members in the House who were actually House impeachment managers in the Senate trial. Jim Sensenbrenner was the other. Now it's 20 years after that, and it's been alleged that another president did something wrong, that he allegedly colluded with the Russians to win an election. I thought the responsible thing to do was to reserve my judgment until the special counsel, this time Robert Mueller, it was an independent counsel back under Clinton, until the special counsel this time completed his report on the matter. He did, and he found no collusion. And he sort of punted on obstruction of justice, but the Attorney General determined no obstruction of justice. So, Mr. Dean, my question to you is this. Rather than reserve your judgment until the Mueller report came out, like I did, you were an outspoken critic of President Trump, and you alleged publicly on more than one occasion, even before the Mueller report came out, that you believed President Trump had colluded with the Russians. Isn't that true?
I don't think I quite said collusion. I think there is evidence, incidentally, in the report of collusion. There have been a number of well-done articles that draw on the different contacts between the Trump people and the Russians and make a fairly strong case for collusion.
I think you did say collusion or colluded. Yeah.
I'd just like to correct you on one fact, that you couldn't have, in 1971, have been attracted to Nixon because of China, because he hadn't gone to China
I voted in 72.
Right. By 72, it was in the during the 72 campaign.
Right. That's what I mean. Yes. Mr. Malcolm, let me go to you. It's my understanding that it's your view that President Trump neither colluded with the Russians nor obstructed justice. Is that correct?
Well, it's the special counsel Mueller's conclusion on the former, and then on the latter, I don't think as a legal matter under the statute that Mueller relied upon, he could be convicted of obstruction of justice, and I thought the determination based on the facts was an eminently reasonable one that he did not engage in obstruction of justice.
Okay, and real quickly, when Attorney General Barr announced his determination on alleged obstruction of justice, was he within the scope of his authority to do so?
He was within the scope of his authority to do whatever he wanted. I thought that the regulations say that he was supposed to make a prosecution or declination decision, which he failed to do. But, you know, he was given the authority to investigate these matters, and he did what he did in his report.
Thank you very much. My time's expired, Mr. Chairman.
Thank you. The gentlelady from Texas, Ms. Jackson Lee.
As I hold this book up, all that we say refers to this roadmap. On June 13, 2017, the acting Attorney General testified before Congress. There was no good cause to remove the special counsel. On June 14, 2017, the President issued a press statement stating he had no intention of firing Mueller. However, on the page 90 of Volume 2 of this report, the report says, quote, "But the next day the media reported that the President was under investigation for obstruction of justice, and the special counsel was interviewing witnesses about events related to possible obstruction, spurring the President to write critical tweets about the special counsel's investigation. The President called McGahn at home that night and then called him on Saturday from Camp David. Pages 85 to 87 of Volume 2 provide more details on the Saturday calls between the President and the White House counsel. Page 85 says on Saturday, June 17, 2017, the President called McGahn and directed him to have the special counsel removed. McGahn was at home and the President was at Camp David. In interviews with this office, McGahn recalled that the President called him at home twice and on both occasions directed him to call Rosenstein and say that Mueller had conflicts that precluded him from serving as special counsel. Page 85 provides further detail about the first call. Quote, "On the first call, McGahn recalled that the President said something like, 'You got to do this. You got to call Rod.' McGahn said he told the President that he would see what he could do. McGahn was perturbed by the call and did not intend to act on the request." Mr. Dean, speaking as a former White House counsel, why would that call from the President perturb McGahn?
Well, I think Mr. McGahn has stated that he was very aware that firing the special counsel could provoke an equivalent to the Nixon Saturday Night Massacre, which, while he wasn't old enough to have remembered it personally, he'd certainly read about it and knew the negative consequences that had flowed from it. And so he stepped away from it and didn't want any part of it.
Page 86 of Volume 2 of the report describes the second call, quote, "When the President called McGahn a second time to follow up on the order to call the Department of Justice, McGahn recalled that the President was more direct, saying something like, 'Call Rod, tell Rod that Mueller has conflicts and can't be the special counsel,' more direct. McGahn recalled the President saying, 'Mueller has to go and call me back when you do it.' McGahn understood the President to be saying that the special counsel had to be removed by Rosenstein. What do you believe, or what is your reaction to this exchange, and would you find such behavior concerning?" Professor Vance, and then Professor McQuaid.
Yes, this conduct to me seems to have all the elements prosecutors would need to have to successfully charge obstruction of justice. There's an obstructive act, the effort to go ahead and have the special counsel fired. There's a nexus to an investigation. At this point, the President is aware that investigation is ongoing. And there appears to be a corrupt motive as well, curtailing the special counsel's investigation. So this entire series of conversations and conduct is deeply troubling.
Thank you, Professor McQuaid.
Yes, Congresswoman, I would agree with that. In fact, it prompted Don McGahn to believe he had to resign because he could not participate in something that would be akin to the Saturday Night Massacre in the firing of Robert Mueller. He understood the significance of it, the consequences, and that it would amount to a crime of obstruction of justice. And this idea that Robert Mueller was in any way conflicted really was frivolous, as officials advised him. It was based on the fact that President Trump said I interviewed for the FBI job and didn't get it. That's not quite right. He came in and provided advice to the White House about what to look for in the next FBI director. And the squabble about a golf club membership was actually, Robert Mueller said, I work so hard that I'd never have time to play golf. Could I have a refund? I am going to resign from the club. And the Trump organization said no. That was the conflict of interest.
Page 78 of the report said, McGahn did not carry out the instruction for fear of being seen as triggering another Saturday Night Massacre, and instead prepared to resign. Page 85 and 86 provide a bit more context to McGahn's state of mind after receiving these phone calls. Quote, McGahn, once concerned about having any role in asking the acting attorney general to fire the special counsel because he had grown up in the Reagan era and wanted to be more like Judge Robert Bork and not Saturday Night Massacre Bork, McGahn considered the president's request to be an inflection point, and he wanted to hit the brakes. Very quickly, Mr. Dean, you mentioned it before, what was the Saturday Night Massacre?
I'm sorry, I missed the end of it.
What was the Saturday Night Massacre?
Saturday Night Massacre occurred in October of 1973 when Richard Nixon removed or fired Archibald Cox as the special counsel, the Watergate special prosecutor, because he exceeded what Nixon thought was his authority to demand tapes, the secret Nixon recordings. He had told him that they would offer them to a member of the Senate, John Stennis, who happened to have a very bad hearing problem, to validate the White House prepared transcripts, and the special counsel Cox rejected it. And Nixon asked the Attorney General to fire him, Mr. Richardson, who refused and resigned. He asked, in turn, Mr. Ruckelshaus, the Deputy Attorney General, to fire Cox. He, too, refused and resigned. It went to the third person in line of authority in the Department of Justice, to Mr. Bork, who did carry out the order.
Thank you.
Thank you. The gentlelady's time has expired. The gentleman from Texas, Mr. Gomert.
Thank you, Mr. Chairman. It's unusual to have the majority fail to properly give the basis for expertise of one of its own witnesses, but Mr. Dean, you've got a lot more qualifications in this area than they actually provided in the introduction. Back when New York Times was more accurate, they reported that in your case, John Sirica, the judge, read the formal charges regarding the conspiracy to thwart the investigation, and he read as follows, that you were suborning perjury, giving false statements and concealing evidence in the trial before Judge Sirica last winter of the men arrested in the break-in, offering clemency to the defendants, paying to keep the arrested men silent, asking the Federal Bureau of Investigation for information, attempting to get the CIA to provide money for the payments. In furtherance of the conspiracy, Judge Sirica continued reading, Dean had committed 6 specific overt acts on or about June 27, 72. He directed G. Gordon Liddy to tell Howard Hunt to leave the United States. He asked General Vernon Walters, the deputy director of the CIA, whether the CIA could use covert funds to pay the bail and salary of those involved in the Watergate break-in. He had asked the president's former private attorney, Herbert Kalmbach, to raise funds with which to make the payments to the Watergate defendants. He had met with Jeb Stuart Magruder on the campaign staff to help Magruder prepare false, deceptive, and misleading testimony to give the grand jury. He had asked John Caulfield to offer executive clemency to James McCord, another of the original defendants, and he had asked L. Patrick Gray, former acting director of the FBI, for reports of information gained in the investigation break-in. We've heard different reports from different people involved. Magruder ended up saying, after different versions, that you were the one that ordered the break-in of the Watergate headquarters, and I see you shaking your head, but did you ever order or convey an order to break into the Democratic headquarters at Watergate Hotel?
First of all, on your description of my pleading guilty.
Yeah, that came from the New York Times. You can take it up with them.
Right.
But did you ever order?
May I explain before I answer?
Well, you can
raise
either
that.
answer the question or not.
Be happy to answer your question.
Please.
The question is, did I ever
Did you order or
Yes,
ever convey the order to break into the Democratic headquarters?
No.
All right, thank you. And I know I wasn't.
In fact, I have no evidence that anybody at the White
Look,
House
I've only got
knew of
5
it.
minutes, and the
Okay.
chairman's not as liberal with us as he is with the Democrats. But for those who are not familiar with the statements here, in his last civil suit, Mr. Dean said, "It could be that I misspoke myself. It's either a misstatement or an incomplete transcription, highly possible. I just misspoke myself. We were trying to paint with the broadest brush we could. I may be not artfully stating here. Maybe it was imposing hindsight on events. That is a less than accurate description," talking about what he had said previously. Obviously, it was a self-serving answer, so maybe I can help some of my colleagues if you're tempted to go after questions like that. But
I don't even know what you're referring to.
it was the last civil suit you were involved in with Mr. Liddy, where he had begged you to sue him because he called you the biggest liar in the world and things of that nature. And you finally sued him with a bunch of other people and ultimately dismissed the case against him without going to trial as he had asked you to do.
That is not
But
correct.
let me, there are similarities, you're right, with regard to Watergate. And both an administration was seeking to illegally spy on another candidate. And both people were hired to attempt to gather evidence that could be used against a candidate. In Watergate, the committee to re-elect the president hired burglars to break into the DNC headquarters. In Watergate, administration officials tried to find ways to use federal dollars to pay for their criminal spying. In Russiagate, members of the federal government used the Intel, DOJ, and FBI communities to attempt to defeat a presidential candidate. Then when that failed, to have him removed from office. In Russiagate, the Clinton campaign and the FBI paid a foreign agent to collude with Russians to produce opposition research that turned out completely false, as the Mueller report indicated, that could be used to commit a fraud upon the FISA court and get multiple warrants to spy on opposition campaign. In Russiagate, it was the Clinton campaign through Fusion GPS in concert with the FBI, possibly intelligence, who hired people to do the spying. And what really bothers me, oh, and by the way, Professor White Vance, I have amazing admiration. I used to tell people, if you ever talk to a lawyer that says, "I'm going to win at court on this and I'll win the appeal," you run from them because they're either incompetent or they're corrupt. But you have such amazing ability. You know you could win at court on an appeal, so I'm in admiration. But let me tell you, the frauds that were committed on the FISA court in this matter and the abuses of American citizens' Fourth Amendment rights and the fact that people who once cared about this country's Fourth Amendment rights are now more concerned with taking out another party's president, making sure he doesn't get reelected, tells me that we are in a greater danger for our Constitution at this time than we were from the outside of World War II. And I appreciate getting nearly 30 seconds short of what y'all did. Thank you.
Gentleman's time has expired without questions. The gentleman from Tennessee.
Thank you, Mr. Chair. First, Mr. Dean, I appreciate your role in history in ending a corrupt administration and restoring justice.
Are you using a mic?
Secondly, you were being asked by Congressman Lee about Don McGahn and his refusal to fire or ask that special counsel be fired, and he didn't want to be compared to Bork and the Saturday Night Massacre. What did you think McCain meant by comparing the special counsel being fired for the Saturday Night Massacre to the role he was asked to engage in? And what was your reaction to the phone calls between the president and Mr. McGahn?
Well, when I read the Mueller report and the details, my first reaction was that McGahn took the high road, acting more like Elliot Richardson and Bill Ruckelshaus, and I thought that was admirable.
He had said he would consider resigning. He was prepared his resignation. Is that correct?
Yes.
The report goes on to detail how trapped McGahn felt. Quoting from page 86 of Volume 2, McGahn recalled feeling trapped because he did not plan to follow the president's directive but did not know what he would say the next time the president called. McGahn decided he had to resign. Page 87 describes McGahn's phone calls later that evening with Priebus and Bannon. Priebus recalled that McGahn said that the president asked him to, quote, do crazy stuff, and I clean it up. But he thought McGahn did not tell him the specifics of the president's request because McGahn was trying to protect Priebus from what he did not need to know. Ms. Vance, if McGahn had carried out the president's orders, would McGahn face legal jeopardy himself?
So it's difficult to answer questions like that without knowing exactly what would have transpired, but there's an enormous risk that he would have. And at that point, there would have been both completed obstruction and a conspiracy to obstruct.
Mr. Dean, as a former White House counsel, are these types of requests in the normal course of business?
No.
Mr. Dean, understanding the circumstances, was Don McGahn's decision to ignore the call to get Mueller fired and McGahn's reaction to resign reasonable and appropriate, commendable?
Yes.
Mr. Dean, understanding your history as someone who was in a similar position but chose differently, what did you think Don McGahn was afraid of? Why did he feel the need to protect both his chief of staff and other advisors?
Well, I think he's somebody who learned from history.
And if we don't learn from history, we're doomed to repeat it, are we not?
Exactly.
Yes, sir. The following quote and questions may pose a parliamentary risk.
No, you don't read that.
Yeah. Let me ask you this. Ms. Vance, you said that there was a different standard, that the collusion was in plain sight, and that you said that we had to prove when they brought a case that they had to win it at trial and they had to win on appeal. Is that the same standard Congress would face in an impeachment hearing?
You know, it's not, and that's a very good point. We've talked a little bit about whether a congressional inquiry would be a do-over of the Mueller investigation. And a congressional inquiry is very different. When prosecutors consider cases, they have to find a federal statute, a law that you all have enacted, and make sure that a defendant has violated, that they can prove a violation of all the elements of that statute. So here, the notion of a corrupt act, a nexus, and corrupt intent. Congress doesn't have those same restraints. When Congress examines conduct in its oversight and its impeachment function, your jurisdiction, as I understand it, is much broader, and you could reach conduct that we might categorize as lawful but awful, something that would be so inappropriate for a president that Congress would determine it needed to be sanctioned.
So kind of, would we have it's a different standard, but would the standard be kind of preponderance of the evidence instead of guilt beyond a reasonable doubt?
So I think that's correct, and that the way that you deal with impeachment proceedings is largely up to how Congress chooses to move forward, the standards that you set, the way that you define high crimes and misdemeanors. It's a process that's less cabined by existing statutory criminal law than the conduct of someone like a special counsel would be.
Thank you. Page 89 of Volume 2 says, and this is directly from the report, substantial evidence indicates the president attempts to remove the special counsel were linked to the special counsel's oversight of investigations that involved the president's conduct, and most immediately reports that the president was being investigated for potential obstruction of justice. And on page 90 of the report, it states there's also was evidence the president knew he should not have made those calls to McGahn. It goes on to say, quote, instead of relying on his personal counsel to submit the conflict claims, the president sought to use his official powers to remove the special counsel. Mr. Dean, do you agree, and why?
Well, I think it was inappropriate to use special counsel, or the White House counsel, and White House counsel rejected being so used.
And Ms. Vance, as a former prosecutor, how would you evaluate the evidence presented in the report, and how does it compare to other cases you've seen prosecuted?
So for prosecutors, when they evaluate evidence, you know, I think it's important just to be frank about this and to note that we're all people, right? We all have different backgrounds, different likes, different views, different politics. What prosecutors are trained to do is to check those beliefs at the door. So the office that I worked in had, I assume, folks who were Republicans and Democrats. We largely didn't discuss politics in the office. We look at the evidence through a very narrow filter. That filter is evaluate what the law says, evaluate the evidence that you have, search for the truth, and charge cases where you believe you can prove beyond a reasonable doubt the elements of a crime. That's how we have to look at the evidence in the Mueller report. And in some instances, Mueller investigates in Volume 2 10 potential instances of obstruction of justice. In my judgment, some of those I would not indict. But in at least 3 core areas, the areas involving removal of Special Counsel Mueller and the President's efforts to get Jeff Sessions to unrecuse and restrict the nature of the investigation, there appears to me to be substantial evidence that would permit prosecutors to move forward.
Thank you so much. I yield back the balance of my time.
The gentleman from Ohio, Mr. Jordan.
Thank you, Mr. Chairman. At a memorial event for David Hamburg, Speaker Pelosi and I had a chance to discuss impeachment. Mr. Dean, who wrote that?
I did.
1 month ago, May 11th, 2019, haven't we been too long in not giving Trump a meaningful moniker? Should it be deranged Don, deadbeat Don, demagogue Don? Thoughts, please, comments. Mr. Dean, who wrote that?
I assume that was mine.
It was yours. 19 days ago, May 22nd, 2019, there was this. We are witnessing Trump's massive cover-up of his criminal behavior. As POTUS, he's incapable of accomplishing anything. Mr. Dean, you know who wrote that?
I suspect that was me again.
It was you. I want to focus on that last sentence. As POTUS, as President of the United States, he, Donald Trump, is incapable of accomplishing anything. When you made that statement, Mr. Dean, what did you have in mind? You thinking about the 3.2% economic growth rate we had the last quarter? Thinking about the fact we got the lowest unemployment in 50 years? How about the fact the hostages are back from North Korea? Maybe you were thinking about this. When you said the President of the United States was incapable of doing anything, were you thinking about the fact that the embassy is now in Jerusalem? I mean, I think about this one. Every single candidate for as many cycles as I can remember, Republican and Democrat, have promised the American people, you elect me, we're going to move the embassy to Jerusalem. And guess what? They get elected and they come up with a million reasons why they can't do what they said they were going to do. But this president didn't. The embassy is now in Jerusalem. So I'm just wondering, what were you thinking about when you said he's incapable of accomplishing anything?
Mr. Jordan, I think that under the parliamentary rules of the House, I'm refrained from addressing a full answer to your question.
You weren't refrained in your tweets and your comments and the things you wrote.
My tweets are not subject to the parliamentarian.
They are subject to
belief.
state of mind and the perspective you bring to this hearing, and I think the American people understand. Let me ask you this then. Did you give advice to Lanny Davis or Michael Cohen prior to Mr. Cohen's testimony to Congress?
No.
Well, you said on Aaron Burnett's show the night before Mr. Cohen testified in front of the Oversight Committee that Michael Cohen you said you had talked to Lanny Davis and that Michael Cohen should hold his testimony as long as possible from Republicans. You didn't say that to Mr. Davis? You said it on Aaron Burnett's show the night before Mr. Cohen testified.
I didn't say it directly to Mr. Cohen was your question.
No, it wasn't. My question was, did you give advice to Lanny Davis or Michael Cohen prior to Mr. Cohen's testimony to Congress?
Yeah, I have known Lanny Davis for almost a couple decades, and we have talked about it. And I did say, as soon as you turn your testimony over, it will be picked apart.
So you instructed Michael Cohen's lawyer to keep information from Republicans, to obstruct the committee work that we were doing in the Oversight Committee just a few months ago? You told that to Michael Cohen's lawyer?
I didn't quite phrase it that way, no.
You know what? They took your advice.
I'm sorry?
They took your advice.
Did they?
Yeah.
didn't
Mr.
know
Cohen
that.
kept his testimony from us for as long as possible. But you know what else Mr. Cohen did that day? Lied. Lied 7 times. And this is what I think concerns so many Americans. This is what concerns, I think, so many Americans about the work that's going on in this Congress, this 116. The first announced witness of the 116th Congress was Michael Cohen, a guy who sits in prison today for lying to Congress. Today, Chairman Nadler brings in front of the Judiciary Committee a guy to talk about obstruction of justice who went to prison in 1974 for obstructing justice.
I did not go to prison.
Okay. You pled guilty to obstruction of justice. I'm glad you got to stay out of prison then, I guess. What bothers me the most, though, is this committee's failure to investigate how the whole Trump-Russia thing started. This is the Judiciary Committee. We're supposed, how this whole thing began. And I said this a few weeks ago, but I want to remind this committee what the Attorney General of the United States said 8 weeks ago when he testified in front of the Senate. Said 4 important things about the beginnings of the Trump-Russia investigation. He said there was a failure of leadership at the upper echelon of the FBI. His words, not mine. Upper echelon. That's certainly true. Comey, McCabe, Baker, Strzok, Page, they've all been fired, demoted, let go, they're gone. Some of them are under investigation by the Justice Department. He said spying did occur. He said it twice. He said there's a basis for his concern about the spying that took place. And he used 2 terms that, again, I think this committee should find frightening and should be looking into. Unauthorized surveillance and political surveillance. Scary terms. So the good news is, even though this Congress has memorandums of understanding between the key committee chairmen on how they're going to coordinate their attack on the president, even though this Congress' first big witness, first big hearing, Michael Cohen, a guy who sits in prison for lying to Congress, and even though we now have a guy testifying about obstruction of justice who pled guilty to obstruction of justice, we should be looking into the things Bill Barr's looking at. Now, the good news is Mr. Durham's doing that. But this is the part I think that frustrates so many. Mr. Chairman, I would hope the Judiciary Committee and the history this committee has for protecting fundamental liberties would begin to look into those key issues, the whole premise for how this Trump-Russia investigation started in the first place. And I'll finish again with this. Emmett Flood wrote a letter to the Attorney General a few weeks back, made an important point. He said, we would all do well to remember, if they can do it to a president, imagine what they can do to you and me. Imagine what they can do to regular citizens across this great country. That should be what this committee most safeguards and most protects. And instead, we got memorandums of understanding between the chairmen. We got Michael Cohen testifying for 7 hours, getting advice from the witness here on obstructing the committee work and not sharing the information with us in a timely fashion. And now we got John Dean, 45 years ago, pled guilty to obstruction of justice, and now coming in to enlighten the Judiciary Committee on Obstruction of Justice when we could be going right to the start of how this whole thing started. I yield back.
I thank the gentleman. Before I go to the next witness, I want to point out that this committee has no memorandum of understanding with any other committee with reference to any investigations. So I don't know. I don't know. This committee has no such memorandum of understanding. And I'm not aware of any others, but there may be. But this committee has no such memorandum of understanding. And number 2, since the gentleman from Ohio cast aspersions on the witness, I would remind everyone that after Mr.
No, I didn't, Mr. Chairman. I read his statements. I did not cast aspersions. I read his statements.
Very well. Since I believe the gentleman cast aspersions...
You're wrong.
Fine. Since I believe the gentleman cast aspersions on the character and truthfulness of the witness, I would remind everyone that after exhaustive testimony in 1973, when the tapes were revealed, it was revealed that everything that Mr. Dean said was correct and truthful. The next witness...
Mr. Chairman, if I could.
The gentleman from Georgia is recognized.
Thank you, Mr.
Gentleman from Georgia is recognized.
Thank you, Mr. Chairman. Mr. Dean, relatively early on in the Nixon cover-up, you told the president that there was a cancer on the presidency, and then you came forward and blew the lid off of the whole cover-up. Then you pleaded guilty, you paid your debt to society, and since that time you have been an exemplary individual committed to truth, justice, and protection of the rule of law, and for that I want to thank you for your service to our country. For the rest of the witnesses, thank you for your testimony today. On January 25th, 2018, the New York Times reported that in June of 2017, the president ordered Don McGahn to have special counsel Robert Mueller fired. Shortly after that news broke, the president went on TV and said, quote, "Fake news, folks, fake news, a typical New York Times fake story," end quote. The report, however, documents a flurry of events. The Mueller report documents a flurry of events behind the scenes after the Times reporting came out. Volume 2 of page 114 of the Mueller report says, quote, "On January 26, 2018, the president's personal counsel called McGahn's attorney and said that the president wanted McGahn to put out a statement denying that he had been asked to fire the special counsel and that he had threatened to quit in protest. McGahn's attorney spoke with McGahn about that request and then called the president's personal counsel to relay that McGahn would not be making that statement. McGahn's attorney informed the president's personal counsel that the Times story was accurate in reporting that the president wanted the special counsel removed. Accordingly, McGahn's attorney said, although the article was inaccurate in some respects, McGahn could not comply with the president's request to dispute the story, end quote. Mr. Dean, why could Don McGahn not comply with this request to put out a statement denying that he had been asked to fire Mueller?
Because, excuse me, because it would have been I suspect what he had in his, I'm projecting myself into his position. He didn't want to put out a false statement. He didn't want to become embroiled in something that he knew was troublesome. He'd already expressed that. It's not dissimilar from a situation I found myself in when Nixon announced on August 29th of 1972 during the campaign that when he was asked why didn't he appoint a special counsel, he said, well, because the Congress is investigating Watergate, the FBI is investigating Watergate, the General Accounting Office is looking into why the burglars had fresh $100 bills in their pocket. There are a number of committees of Congress that are starting to look at it. But he said, most importantly, my White House counsel, John Dean, has investigated this entire matter and found that nobody presently employed in this White House had anything to do with this bizarre incident.
And that was a lie?
And that was a lie. It was the first I heard of my investigation. And I was then asked after that repeatedly to issue a report based on my non-existent investigation.
And you declined to do so? Why?
I did because it would have been a lie.
And what would have been the result for you?
Theoretically, depending upon the venue, it could have been anything from a false statement to a perjurious statement.
You could have gone to prison, in other words.
Yes.
For doing what you were asked to do.
By the president.
Thank you. Page 115 of Volume 2 states, quote, on January 26, 2017, Hope Hicks recalled that the president asked White House Press Secretary Sarah Huckabee Sanders to contact McGahn about that New York Times story, and McGahn told Sanders there was no need to respond and indicated that some of the article was accurate, end quote. Mr. Dean and also Professor Vance and Professor McQuaid, what is your reaction to this internal effort to get McGahn to dispute the press report? Mr. Dean?
I'll defer to the ladies to start first.
Well, Congressman, I'll just say that this is part of 4 successive steps that the president takes in an effort to get the White House counsel, Don McGahn, to change the story. And this isn't just in response to a press report. The Mueller report is very careful to say that at the point that this cascading series of requests go from the president to McGahn, they're outside of that window where you would just be trying to respond in the press. And this looks like an affirmative effort to create an official record that would confirm the president's story here, which is that he did not try to get McGahn to fire Bob Mueller. And so there are actually 4 conversations. As you've reflected, there's the counsel-to-counsel call. There's Hope Hicks's testimony about the president's conversation with his press secretary. He has an additional conversation with Rob Porter, the staff secretary, and then finally, there's this Oval Office meeting where the president says to Don McGahn, look, you need to change your story. I did not ask you to fire Mueller. And McGahn pushes back. And so we have this series of efforts that don't culminate in obstruction because McGahn refuses to cooperate. But as Professor McQuaid has already told us, This sort of crime, obstruction of justice, does not depend upon completing the crime. The attempt to obstruct justice is really the problem here. That's what interferes with the functioning of our criminal justice system, and that's why this conduct is so deeply troubling.
The time of the gentleman has expired. The gentleman...
Could I ask that Ms. McQuaid, Professor McQuaid, also be able to answer that
If
question?
she's brief.
I will be brief. The only thing I would add to that is it demonstrates why it's important to look at the totality of the circumstances, and the conclusion that Robert Mueller makes with regard to all 4 of those incidents that Professor Vance referred to is that there was substantial evidence of an intent on the part of President Trump to prevent scrutiny of President Trump and his campaign.
Thank you very much.
I yield back.
The gentleman from Florida, Mr. Gates.
Thank you, Mr. Chairman. I seek unanimous consent to enter into the record a December 30th, 2005 essay written by Mr. John Dean entitled George W. Bush as the New Richard Nixon, both wiretapped illegally and impeachably.
Without objection?
Mr. Dean, how many American presidents have you accused of being Richard Nixon?
I actually wrote a book about Mr. Bush and Mr. Cheney with the title Worse Than Watergate.
So it's sort of become a cottage. Did you make money on that book?
It was a very successful book,
How much
yes.
money did you make on it?
I'm sorry, I don't have any idea.
More than $1 million?
No.
More than $500,000?
I said I don't have any idea.
How much money do you make from CNN?
I don't really know exactly.
I think I'm going to object to
Wait
Wait
a second. Mr. Dean has made a cottage industry out of accusing presidents of acting like Richard Nixon. I would like to know how much money he makes based on making these accusations and exploiting them for his own economic benefit. And you're saying that's not a lot?
Mr. Gates, I appreciate you were not born at the time this all happened. It's not by choice that I've done a lot of this. It's and I've been dragged into it.
Who forced you to accuse George W. Bush of being Richard Nixon?
Who forced me to? It was right after I had spent 10 years in a lawsuit knocking down false statements about what my role had and hadn't been.
Well, let's speak now to the truth or falsity of statements. Do you have personal knowledge regarding the truth or falsity of a single material fact in the Mueller report?
I think if you recall, the first thing I said, I'm not here as a fact witness.
You're here to provide historical context.
Exactly.
And throughout history, you accuse presidents of acting like Richard Nixon, and you make money off of it, right?
Not all presidents, no.
No, but a few, more than one.
Those who do act like him, I pointed out.
Let me ask you this question. How do Democrats plan to pay for Medicare for all?
I'm sorry?
Well, I figured if we were going to ask you about stuff you don't know about, we'd start with the big stuff. So do you know how they plan to pay for Medicare for all?
Who? The Democrats or which candidate? Or can you be more specific?
Let's get specific to Nixon, since that appears to be why you're here. Do you believe?
Well, actually, Nixon did have a health care plan.
Good. Well, do you believe if we turned the lights off here and maybe lit some candles, got out a Ouija board, we could potentially raise the specter of Richard Nixon?
I doubt that.
Well, it seems to be the objective. You know, here we sit today in this hearing with the ghost of Christmas past because the chairman of the committee has gone to the Speaker of the House and sought permission to open an impeachment inquiry. But she has said no. And so instead of opening the impeachment inquiry into Donald Trump, which is what the chairman wants to do and what I presume a majority of Democrats want to do, we're here reopening the impeachment inquiry potentially into Richard Nixon, sort of playing out our own version of that 70s show. And what I really regret,
it is striking, Mr.
You're
Gates.
here as a prop. You are functionally here as a prop because they can't impeach President Trump because 70% of Democrats want something that 60% of Americans don't. So they're in this no-win situation, and you sit before us here with no knowledge of a single fact on the Mueller report, on a hearing entitled Lessons from the Mueller Report.
Mr. Gates, can I answer your question, please?
It's not your time, Mr. Dean, it's my time. So here's the deal, right? We have a false accusation against the President of the United States that he was an agent of Russia. My colleagues on the Democratic side made that accusation. And so where do we go from here? Either we look into how the president reacted to a false allegation against him, or we look into why for 22 months, we allowed a false accusation to tear this country apart. Now, to me, it seems like a far more relevant inquiry to figure out why the FISA court was lied to, something that you have spoken a great deal about, Mr. Dean, to find out why the recordings and the transcripts from George Papadopoulos, where he asserted that he wasn't doing any work with Russia, was not brought before the FISA court. None of that. We also would love to know why the FBI turned from an organization that was supposed to be investigating crimes into one that sought to shape public opinion. You had Comey and McCabe and that whole regime of leadership lying and leaking. And the reason they were doing it is because they didn't really think that the job of the FBI was to investigate and bring cases for prosecution. They thought the role of the FBI was to try to shape public opinion. And that's really why we're here. And that's what I really think all Americans ought to have an interest in stopping. And you held these views. You wrote them down. You said that illegal surveillance was one of the worst things that we should fight against as a government. And now here we are continuing to engage in this frivolous exercise of going after the president, despite the fact that there was absolutely no collusion. You guys need to get your act together and figure out if you're going to open an impeachment inquiry or not, because this is a straight-up fiction. I yield back.
Gentleman's time has expired. The witness may answer the question.
That was a speech. I don't believe I can respond to it. It's not sufficient time.
The gentleman from Florida, Mr. Deutsch.
Thank you, Mr. Chairman. Returning to the facts of the Mueller report, something that my colleagues on the other side are taking great pains to avoid. Let's go back to where we left off. After McGahn initially rebuffed the White House's request to dispute the press reports that the president asked him to fire the special counsel, the report describes additional efforts pursued by the White House to counteract that reporting. Pages 115 to 116 of Volume 2 details an interaction between President Trump and White House senior aide Rob Porter. And I quote the Mueller report, quote, on February 5, 2018, the president complained about the Times article to Porter. The president told Porter that the article was BS. For the record, the president did not abbreviate. And he had not sought to terminate the special counsel. It then says, and I quote, the president then directed Porter to tell McGahn to create a record to make clear that the president never directed McGahn to fire the special counsel. Porter thought the matter should be handled by the White House Communications Office, but the president said he wanted McGahn to write a letter to the file, quote, for our records, and wanted something beyond a press statement to demonstrate that the reporting was inaccurate. The president referred to McGahn as a, quote, lying bastard, and said that he wanted a record from him. Porter recalled the president saying something to the effect of, quote, if he doesn't write a letter, then maybe I'll have to get rid of him. Mr. Dean, as former White House counsel, what does it mean when you're being asked to write a letter to the file for our records? And what is the purpose of such a document?
Well, this appears to have been a false record that would be there that could later be used to impeach Mr. McCann should he become a witness. So it was a lacing of the record in a way that was favorable to the president and could later discredit McGahn's testimony.
Is it your understanding that a White House counsel can be fired for refusing to write such a letter or for refusing to dispute truthful press reports of his or her own actions?
The White House counsel can be dismissed for any reason. He serves at the pleasure of the president.
So on page 116 of Volume 2, there's a description of Porter and McGahn's subsequent discussion about the press reports and the president's request. Quote, McGahn had planned to resign rather than carry out the order, although he had not personally told the president he intended to quit. Porter told McGahn that the president suggested that McGahn would be fired if he did not write the letter. Professor McQuaid, what's your reaction to this request for a letter from McGahn?
This to me, Congressman, is perhaps the most serious allegation of obstruction of justice in the entire report. This is asking Don McGahn to create a false document, to lie, to manufacture evidence. This is the kind of thing that gets charged as obstruction of justice all the time. And even Mr. Malcolm and Attorney General Barr would agree, I think, that this constitutes obstruction of justice even by a president because it is not within his permissible executive powers.
And Professor Vance, is there a federal statute against falsifying records?
So there actually is, but Mueller, in his consideration here, looks at the obstruction of justice statutes. He looks at 1503, 1505, 1515. And without going sort of into the arcane way that the obstruction statutes function together, it's clear that this conduct would be violative at a minimum of the catch-all clause in 1512.
Right, and so the day after Porter was unable to convince McGahn, the report describes a meeting between McGahn and the President of the United States. In advance of the meeting, the President's personal attorney called McGahn's personal attorney and said, quote, McGahn could not resign no matter what happened in the meeting. On page 116 of Volume 2, then details the meeting, quote, the President began the Oval Office meeting by telling McGahn that the New York Times story did not look good, and McGahn needed to correct it. McGahn recalled the President said, and I quote, I never said to fire Mueller. I never said fire. The story doesn't look good. You need to correct this. You're the White House counsel. The report then goes on to say, quote, McGahn told the President he did not understand the conversation that way and instead had heard, call Rod, there are conflicts, Mueller has to go. The President asked McGahn whether he would do a correction, and McGahn said no. Professor McQuaid, what's your reaction to this meeting as I've described it thus far?
What McGahn says is that he thought that President Trump was testing his mettle, that is, seeing how firm he was in his recollection of what had happened and whether he was going to be movable. And McGahn was steadfast and stuck to his guns and said, no, this is what happened. You did ask me to fire. Maybe you didn't use the word fire, but you said he needs to go. You have to remove him. And so even if the precise words were not accurate, the gist of the story was, and McGahn was steadfast in his refusal to deny it falsely.
Thank you, Professor McQuaid. Thanks to all of our witnesses, and appreciate the attention that you're giving the facts as we proceed through this. Mr. Chairman, just if I may, we were told earlier by one of our colleagues what this committee should most safeguard and protect. We were given some guidance on what that should be, and I think as we work through this, it's clear that what this committee should most safeguard and protect is getting the truth and defending the Constitution. I yield back.
I thank the gentleman for the observation. The gentleman from Arizona, Mr. Biggs, is recognized.
Thank you, Mr. Chairman. You know, I appreciate all of you being here today, but I do find this to be a bit of an absurd hearing that we're holding today. Let's talk about Mr. Dean for just a second. No, you're no fall guy in the Watergate scandal. The FBI referred to you as the master manipulator of the cover-up.
Incorrect.
The U.S. attorney said you were at the center of the criminality. The special counsel's office found 19 material discrepancies between your testimony and what was found recorded on White House tapes. What was actually recorded, 19 material discrepancies. That makes you, as an additional convicted felon, sentenced 1 to 4 years in prison. You tell us today you didn't go to prison, and that's true. You didn't go to prison. You went to a special witness facility while you were testifying after you had turned state's evidence. Allegations against you included the conspiracy to obstruct justice, rehearsing Jeb Magruder for his false grand jury testimony, which would be subordination of perjury, destroying documents retrieved from Howard Hunt's office, which would be destruction of evidence, taking $4,000 of campaign funds from your office safe to pay for your honeymoon, that would be embezzlement, and improperly disclosing prosecutorial information to Watergate Defense Counsel, which would be misuse of government information. Those things would make you, in my opinion, an inherently incredible witness. But see, we're not just talking about your credibility as a witness. You're a biased witness as well. You spent the last 45 years trying to rehabilitate yourself, and I don't blame you. And you've written numerous books. You've claimed multiple Republican administrations as being worse than Watergate. You wrote a book in 1987 called Worse Than Watergate, and it's about Bush and Cheney. You later wrote another book, having called this president, by the way, a nitwit. But your later book is called Broken Government, How Republican Rule Destroyed the Legislative, Executive, and Judicial Branches. Somehow, the impeachment against former President Clinton was you described as absurd, but every Republican president since virtually has been accused of impeachable offenses by you. That makes you a biased witness, incredible and biased. Moreover, you've come in here today, and it's the one thing I absolutely agree with you on. You don't have any expertise with regard to facts. You're not the fact witness. You said that. It's written in right in your report. I don't disagree with that at all. I agree with you 100%. But you're trying to give us historical context. And when you try to give us historical context, I refer you back to, number one, incredible witness. Number two, biased witness. So much of what you say seems very difficult to accept at face value, quite frankly. So I had to leave it there. But I would just say that our chairman has said that obstruction of justice is a, quote, serious crime that strikes at the heart of our justice system, close quote. Is it not ironic, then, that you are brought here today as one convicted of obstruction of justice with no information regarding the underlying Mueller report? In fact, none of the witnesses have it. This is all conjecture, legal posturing, discussion back and forth, banter back and forth. It doesn't get at the heart. You don't know any more than any of us. Everybody up here, I would hope, has read the Mueller report. If you've read it, and it sounds like most of you have, and all of you have, then that's a good thing. But it doesn't mean you have any kind of special kind of information to give to us today. So that's a problem. I'm going to cut right now to this distinction that was made by Professor McQuaid, which I thought was quaint. Execute versus faithfully execute. Who determines whether someone's faithfully executed it? Well, it would be the executive branch. Well, that'd be the president. So let me give you some things. Delaying the ACA past its enactment date. Would that be faithfully executing? Probably not. Refusing to enforce federal drug laws under, quote, prosecutorial discretion. Probably not faithfully executing. Allowing the IRS to target conservative groups. Probably not faithfully executing your duties under the law. Creating DAPA in addition to DACA, which was ruled unconstitutional by the U.S. Supreme Court. Probably not faithfully executing your duties. Attempted to appoint 3 NLRB members and the CFPB head, all found to be illegal. Probably not faithfully executing your duties. And if your administration had lost more Supreme Court cases than any other modern president, one might question whether you were faithfully executing your duties because the United States Supreme Court repeatedly rejected what you were attempting to do. So I find it interesting that that was even brought up, but again, this is an absurdist act. But I will say this, at least when I read Ionesco or Pirandello, I know one thing, they're trying to really get at something serious. And this has turned into a vaudevillian farce to me. My time has expired.
I'll permit Mr. Dean to answer the aspersions on him.
Mr. Biggs, if I might, I did my best to tell the truth when I was asked. I did my best internally to break up the Watergate cover-up when I realized we were on the wrong side of the law. It was an unpleasant role to have to fulfill, but I do know this subject pretty well. I spent 4.5 years recently transcribing all of Mr. Nixon's Watergate conversations. Learned a lot I had no knowledge of. When I served as White House counsel, it was 255 days after the arrest of the Watergate that I had my first meeting with Richard Nixon. I would have 39 meetings. 37 of them are recorded. 13 are telephone calls, 26 are meetings. Earlier it was mentioned that I had somehow misrepresented these meetings. The person who did that did it based on 9 tapes when there are 39. Others have looked at all of them and say, while I conflated some dates, I got the gist of all of the conversations correct. As a former U.S. attorney, I think you can appreciate when somebody's in the witness protection program, there's a pretty serious reason. I was in and out of it for 18 months because of the death threats. That wasn't a pleasant place to be. Finally, I noticed that you went to ASU. I happen to have been the Goldwater Professor of American institutions there, and I guarantee you I tried to educate those students on the facts. So you might want to take it up with the regents if you have these kinds of problems with me.
Gentleman's time has expired. The gentlelady from California, Ms. Bass.
Yes, I want to continue to focus on page 116 of Volume 2. The President asked McGahn in the meeting why he had told Special Counsel Office investigators that the President had told him to have Special Counsel removed. McGahn responded that he had to, and that his conversations with the President were not protected by attorney-client privilege. Mr. Dean, as a former White House counsel, why would such conversations not be covered by attorney-client privilege?
Congressman Bass, the rule, there could be partial coverage of attorney-client. What happened during the Clinton impeachment is that this was tested in the courts in the District of Columbia and determined that indeed there was no such privilege, that government lawyers really do owe it to the public to be, when asked, able to report their relationships with their principals. So it's more of a matter of, transparency than privacy in these instances. So Bruce Lindsay was ruled, for example, in the Lindsay case, to not have a privilege with the First Lady, Hillary Clinton.
Thank you. Before continuing, I'd like the witnesses to look at the demonstratives displayed, which goes through a timeline of these events. And I'd like to ask Professor Vance, what is your reaction to the events in this timeline?
So this is the timeline. I'm sort of trying to read it quickly as we look at it.
The mic, please.
Oh, sorry, y'all. I'm reading the timeline as I'm responding to your question. But this is, again, the president's, this cascading conduct where the president tries repeatedly to get McGahn to fire the special counsel. We already know what his reaction was to news of the special counsel's firing. Now he seems determined to have him removed, and Don McGahn, by the same token, as Mr. Dean has explained, realizes that he cannot participate in that for the obvious reasons. This reflects these 4 different steps that the president takes, repeatedly trying to get McGahn to fire the special counsel.
Thank you. Well, still on page 116, the report says, and I quote, the president then asked, what about these notes? Why do you take notes? Lawyers don't take notes. I never had a lawyer who took notes. McGahn responded that he keeps notes because he is a real lawyer, and explained that notes create a record and are not a bad thing. The president said, I've got a lot of great lawyers, like Roy Cohn. He did not take notes. So, Professor McQuaid, what purpose or function does note-taking serve for lawyers? What are the negative consequences if a lawyer does not take detailed notes, especially when interacting with clients?
I think an ethical lawyer takes notes because he wants to preserve a record of what actually happened, so that if there is a question a year or 2 years from now, we can go back and look at the notes and have a full understanding of the facts. The reason to not take notes, I maintain, one of which would be to maintain plausible deniability. There is no record of what actually happened, and you maintain the ability to deny things if there is no record.
Mr. Dean, is it common practice or in the ordinary course of business for a White House counsel to document or take notes of his or her meetings in the White House, including those with the president?
I think it depends on the counsel. I was once asked by one of the senior members of the staff, Richard Moore, if I was keeping notes. I was talking to him about some of the problems when he was asked to assist me with the bogus report. And I felt he was an attorney, had gone to Yale. I thought I should square with him and tell him that there were reasons I wasn't taking notes because he thought these were pretty historic events. And I advised him that I thought it would be very dangerous to take notes. Anyone who's listened to the Nixon tapes realize how dangerous indeed it might be to have those notes.
Were you ever
I wished I had.
Were you ever told not to take notes?
No. In fact, H.R. Haldeman, the chief of staff, took remarkable notes in telephone calls and in the Oval Office. but his notes were only follow-up activities that he was responsible for. They've often been misread.
And Professor Vance, has a client ever asked you not to take notes of your conversations with them? And would your answer be different if you knew the client was facing some type of investigation?
So I've spent most of my life as a federal prosecutor, but I did spend 5 to 6 years in private practice. I've never had a client ask me to not take notes. And in fact, that would be a red flag that there was a problem if someone did.
Thank you. I yield.
Thank you, Mr. Chairman. Everybody knows what's going on here. For 2.5 years now, the American people were force-fed this monstrous lie that Donald Trump's a traitor who conspired with a hostile foreign government to steal the election. This lie was concocted through a phony dossier commissioned by the Clinton campaign. It was used by the highest officials in the FBI, our intelligence agencies, and our Justice Department first in a failed attempt to interfere with our 2016 presidential election, and then to undermine the constitutionally elected President of the United States. The first calls for Donald Trump's impeachment were heard within 1 week of the election. That was 2 months before he was even inaugurated as president. The day after the 2018 election, the chairman was overheard discussing his impeachment plans on an Acela train. Despite an outrageously biased team of partisan zealots who were assembled by Mr. Mueller, which initially included the now infamous Peter Strzok and Lisa Page, and some of the most abusive prosecutorial tactics employed, the $25 million, 22-month investigation found no evidence to support the collusion lie. So now we have a new lie, that the president obstructed justice in the investigation in which he was falsely accused of treason. The only evidence we're presented is that he was blowing off Trumpian steam behind closed doors in words that amounted to no action whatsoever. And they ignored the fact there was no underlying crime. His campaign and administration turned over every document requested of them, some 1.4 million pages. He waived executive privilege to allow his White House counsel to testify. And, by the way, he had the authority to do directly what he's accused of suggesting others do, and he did not. I have to tell you, if every politician told who tells his staff, "I'd like to strangle that guy," is ipso facto guilty of attempted murder, well, you might as well turn out the lights and close the doors in this building. Now, Mr. Malcolm, you're a former assistant U.S. attorney and deputy assistant attorney general. I'd like your professional opinion of several aspects of the Mueller report. The entire genesis of the Russia collusion hoax was the Steele dossier and how it was used by government officials to promote this false narrative, to influence our election, and to use it as the basis of warrants to spy on the Trump campaign. Yet the Mueller report largely ignores the very seminal acts that gave rise to these charges in the first place. Does that raise any red flags with you?
First of all, thank you for the question. I was feeling lonesome here. I look forward to reading the Department of Justice's Inspector General's report on that very issue, but there is scant mention of it in the Mueller report. That's true.
Does that trouble you?
You know, look, he did what he did. He had his focus. There are other things that he could have focused on that I wish he would have, but it seems that those matters are getting the attention that they deserve now.
Well, two revelations have already arisen involving the Mueller report. One concerns the report's recount of a conversation between John Dowd, the president's counsel, and Robert Kelleher on behalf of Michael Flynn. It omitted about half of Dowd's words to give the false impression of suborning a witness. The other thing we've learned recently is that references to Konstantin Kilimnik's interactions with Paul Manafort in the Mueller report identify him as having ties to Russian intelligence, but omit the fact that Kilimnik was, in fact, a U.S. intelligence asset. Do these material omissions raise any concerns with you?
Well, I've read both of those. With respect to the references to the joint defense agreement, even when I read it at the time in the Mueller report, there's nothing wrong with the defense counsel for another person calling up, even someone who's cooperating with the government, and said, look, one, you can't breach what was said in the joint defense agreement.
But omitting the
tell me what you
exculpatory words.
I'm sorry?
Omitting the exculpatory words in the report, does that bother you?
Yes, that bothers me, and I thought it was an unfair characterization in the report, even when I read it at face value.
And the omission that Kalemnik was in fact a U.S. intelligence asset?
If that's true, then I would be bothered by its omission.
It was recently revealed that Trump campaign workers were lured overseas by U.S. intelligence agencies specifically to evade U.S. laws on observation. Does this raise any concerns with you?
Yes, it would certainly raise concerns, and that's why I assume that matter is now going to be covered.
We're regaled with all of Trump's bombastic statements behind closed doors, telling his staff to do this and do that. But if the president had actually been serious, why couldn't he have simply picked up the phone and said, Mueller, you're fired?
Well, that's a very good point. So when you are going to look at the context in which statements are made, it also includes the individual involved. And let me be clear, I'm not here to defend the president's conduct, just the rule of law. You know, there are many things the president does that I wouldn't do, but just because somebody acts impulsively or in an uncivil manner does not mean that they commit a crime. He has surrounded himself with people who are used to his style, who sometimes realize that this is a president who publicly and privately acts impulsively and vents, and sometimes they ignore him. And in fact, there have been no repercussions to any of the people who ignored him. And you are correct, the president could have fired Rod Rosenstein, he could have rescinded the regulation that called for the, when Mueller could have been fired, he could have fired Mueller, he could have done any number of those things. It would have caused political problems for him, but he could have done them, and he didn't.
Thank you.
Gentleman's time has expired. The gentleman from Rhode Island, Mrs. Cicilline.
Thank you, Mr. Chairman. Again, I'm going to return to some other attempts to remove the special counsel that are detailed in the Mueller report. The report goes on to document other efforts to remove the special counsel from office or limit his investigation. On page 91 of Volume 2, the report identifies an incident involving Corey Lewandowski, a senior Trump campaign advisor. On June 19th, shortly after McGahn initially refused to take the steps to fire special counsel Mueller, as we've discussed already, the report says, and I quote, during the June 19th meeting, Lewandowski recalled that after some small talk, the president brought up Sessions and criticized his recusal from the Russia investigation. The president told Lewandowski that Sessions was weak and that if the president had known about the likelihood of recusal in advance, he would not have appointed Sessions. The president then asked Lewandowski to deliver a message to Sessions and said, write this down, and I quote, write this down. This was the first time the president had asked Lewandowski to take dictation, and Lewandowski wrote as fast as possible to make sure he captured the content correctly. The alleged dictated message, as noted on page 91, is as follows, and I quote, the president directed that Sessions should give a speech publicly announcing, I know that I recuse myself from certain things having to do with specific areas, but our POTUS is being treated very unfairly. He shouldn't have a special prosecutor or counsel because he hasn't done anything wrong. I was on the campaign with him for 9 months. There were no Russians involved with him. I know it for a fact because I was there. He didn't do anything wrong except he ran the greatest campaign in American history, end quote. The dictated message went on to state that Sessions would meet with the special counsel to limit his jurisdiction to future election interference. And I quote, now a group of people want to subvert the Constitution of the United States. I'm going to meet with the special prosecutor to explain this is very unfair and let the special prosecutor move forward with investigating election meddling for future elections so that nothing can happen in future elections, end quote. Professor Vance, what is your reaction to the contents of this dictated message to the Attorney General?
Congressman Ranking Member Collins started this hearing by talking about how serious the events that are recounted in Volume 1 of the Mueller report and often ignored are, and that's the attack on our country by Russia, the effort to interfere with our election, an ongoing and a sustained attack on the United States. What the President of the United States is trying to do here through Corey Lewandowski is to have Senator Sessions curtail the extent of the Mueller investigation so that that attack by Russia would have been off the table. There are other takeaways, but that, I think, deserves our attention, that the president, in order to save himself, was willing to forego any investigation into what Russia had done to this country.
And Professor McQuaid?
Yeah, I think that the most significant part of that is that if you think about what President Trump wanted to do, he wanted to focus the investigation solely on future investigations. That meant no scrutiny of the 2016 election. That, in part, was perhaps to prevent scrutiny of his campaign's misconduct or delegitimizing his campaign, or conduct by members of his family or campaign that could have amounted to crimes, which of course he didn't know the conclusion of Mueller's report at that time. But the impact on national security, think about that. He wanted Robert Mueller not to examine why Russia and how Russia interfered with our election. That is a threat to our national security, and that was a failure of responsibility of the President of the United States, who has a duty to faithfully execute the laws.
Returning again to the Mueller report, pages 92 through 93 of Volume 2, describes that Lewandowski was unable to get the message to Attorney General Sessions, but a month later, and I quote, in the July 19th meeting with Lewandowski, the President raised his previous request and asked if Lewandowski had talked to Sessions. Lewandowski told the President that the message would be delivered soon. Lewandowski recalled that the President told him that if Sessions did not meet with him, Lewandowski should tell Sessions he was fired. Immediately following the meeting with the President, Lewandowski saw Dearborn in the anteroom outside the Oval Office and gave him a typewritten version of the message that the President had dictated to be delivered to Sessions. Mr. Dean, is it in the normal course of business to use non-government personnel to communicate with cabinet-level officials?
Well, I think presidents have their kitchen cabinets through which they often undertake some actions, but not of this nature, where you're trying to remove an attorney general would be highly unusual. What struck me in reading all this, as with the references to Porter, is that there's no conspiracy charge in here, because these people, while they went up to the line, it's not clear how close they came to agreeing and participating or just stepped back.
Thank you, Mr. Dean. Mr. Chairman, I would just note for the record before I yield back that there's been a lot of clamor for fact witnesses, and maybe our colleagues on the other side of the aisle would find the same strong voice in condemning the administration's efforts by encouraging witnesses to defy subpoenas and refuse to come before this committee. Maybe they will join us in our ongoing effort to get witnesses before the committee. And finally, there's been a lot of discussion about the origins of the Russia investigation. I would just suggest to my colleagues on the other side of the aisle, go to pages 80 through 96, and the American people as well. It gives significant detail about the beginning of this investigation and the role of George Papadopoulos, and I think it should settle all your questions. And with that, I yield back.
I thank the gentleman for yielding back, and it is true that fact witnesses have been ordered by the White House not to appear before this committee, but we'll get them. Gentleman from Virginia, Mr. Klein.
Thank you, Mr. Chairman. It's my hope that we do have the witnesses in question, because this has really degenerated into a sad spectacle. The majority has a bunch of questions. They have neat charts that all have questions that are really meant for the Attorney General or Special Counsel Mueller or Mr. McGahn. But instead, we have these witnesses here. I hope that the majority would enter into real negotiations with the White House instead of what happened, which was several weeks of demanding that the Attorney General release grand jury testimony against federal statutes and break the law in violation of code, and instead move off of these demands that we have staff, lawyers, ask questions of the Attorney General, which has not been done in any other case outside of an impeachment hearing, and actually negotiate with the Attorney General. And I bet we could have these questions before the actual fact witnesses instead of MSNBC stars and stars of miniseries. You know, and Mr. Dean, I'd say in '79 when you were played by Martin Sheen, that was great. In '95, you were played by David Hyde Pierce. That's a little bit of a step down there. And in '99's Dick, you were played by Jim Brewer from Saturday Night Live. I hope there's not another remake of that, because I don't know where you go after that. But I want to focus on some of the statements that have been made about Volume 1. You know, if we were really doing the work of the people here, we would be focused on Volume 1 and how to stop Russian interference in our election system. Instead, we're focused on, I guess, talking to some of the final people who really believe that there still is some kind of collusion. I'll ask Ms. Vance, Professor Vance, on November 30th, 2018, you tweeted, "At some point, all the times he said no collusion are going to come back to haunt this president." Do you still believe that there was collusion?
So it's important to note, as Mueller does.
That's a yes or no.
Congressman,
I've got 2:45 left.
It's not a yes or no answer.
Okay, then let me go to your next
There's
tweet.
a difference
I'm
between
going to reclaim
collusion
my
and
time.
conspiracy.
Okay, do you believe there was conspiracy?
Mueller finds that he has insufficient evidence to charge a conspiracy, but he also notes that much evidence was kept from him, that people took the Fifth Amendment, people lied to him, people destroyed evidence on applications like WhatsApp.
Okay, so he
And
didn't exonerate, but
He
do you-
notes that if he had had the opportunity to get that evidence, he might have been able to view the situation differently.
As a former prosecutor, do you believe that it's the job of a prosecutor to exonerate the defendant, potential defendant?
In a typical case where I'm looking at indicting a bank robber, say, or a drug case, I would agree that it's not my job.
Okay. On July 6, 2018, you tweeted, "The president's sowing hatred, fear, and distrust in hopes he can divide the country enough to survive when the truth comes out about his campaign's collusion with Russia." Do you believe the truth has come out about the president's collusion with Russia and that there is none?
Again, I think that there's an enormous difference between collusion and conspiracy. There's evidence of a lot of contact, a lot of welcoming with open arms by this president, cooperation and help on the campaign from Russia. So the American people should read Volume 1 of the report and draw their own conclusions about what that gap is between collusion and Mueller not having sufficient evidence to charge a conspiracy.
On January 8th, you tweeted, "Video clips of people saying no collusion have not aged well. I would argue that these tweets have not aged well." And with that, I would yield to the gentleman from Ohio.
I thank the gentleman for yielding. Mr. Malcolm, I have the appointment of Special Counsel Mueller, the one-page document that makes it happen on May 17th, 17, signed by Rod Rosenstein. In there, he says the last point, item D, section 600.4 through 600.10 of Title 28 of the Code of Federal Regulations are applicable to the special counsel. And 600.8C says this: at the conclusion of the special counsel's work, he or she shall provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by the special counsel. As I read that, it seems to me that the special counsel was either supposed to prosecute or decline to prosecute. Not say, I can't decide, not say I can't decide because there's a OLC opinion at the Department of Justice. He's supposed to pick one or the other. Do you read it that way?
Yes, I do.
And you said that in your testimony. I think your written testimony, I don't know if you said that in your statement, but in your written testimony, you said it was the duty of the special counsel to provide the Attorney General with the confidential report explaining what I just read, the prosecution or declination decision reached by the special counsel. So you think Robert Mueller failed to do his duty in making a decision?
That is my opinion.
Okay. With that, I yield back, Mr. Chairman.
Gentleman yields back. The gentleman from California, Mr. Suave.
Thank you, Mr. Chairman. And before continuing, I'd like to ask the witnesses to direct their attention to what's referred to as slide 7. It's a timeline. It goes from June 14, 2017, with an NBC News story saying Trump being investigated for possible obstruction of justice. And then it goes through various tweets from the president, including on June 15, "You are witnessing the single greatest witch hunt in American political history, led by some very bad and conflicted people," to a June 17 story of Trump directing McGahn to fire the special counsel. On June 19, Trump dictates to former campaign manager deliver a message to the Attorney General directing him to not investigate Trump, concluding on the 6th of December with Trump pressuring the Attorney General, special counsel, to protect Trump and shield the president from the ongoing Russia investigation. And just going back, Professor McQuaid, to Mr. Cicilline's questioning, how do you interpret the directives to Corey Lewandowski by the president? What was your interpretation of that type of behavior and directive?
Directing Corey Lewandowski to go see Attorney General Jeff Sessions and ask him to take an unethical act in unrecusing himself strikes me as a matter that would go even consistently with Mr. Malcolm's theory and Attorney General Barr's theory beyond the scope of executive powers. He is acting outside by asking a private citizen to persuade Attorney General to unrecuse himself and to limit the scope of the investigation to only future elections is obstruction of justice under any theory.
The report concluded the president's efforts towards Sessions were because he believed Sessions would shield the president from the ongoing Russia investigation. Ms. Vance, looking at the timeline, can you give us your reactions to this portion of the Mueller report?
Something that we've talked about is the need to look at the entirety of the facts. You know, we want to focus on these 10 events and determine whether there's any misconduct, because as Congress, you all need to look at that. Also, though, as we look at this timeline, because this really blends two of the acts that we've been talking about, this effort by the president to fire the special counsel, but also this effort to get then Attorney General Sessions to unrecuse and protect the president. And so these acts put together really show us a great level of intent. You know, I would make the point, Representative Smallwell, that when we reach the end of this, we essentially have a president who's saying, maybe I robbed some banks in the past, but I don't want you to look at that, Mr. Attorney General. I just want you to investigate whether I rob any banks in the future. And when we put it in those terms, I think that pops this into a little bit of relevance for us.
Page 97 of Volume 2 summaries, quote, taken together, the president's directives indicate Sessions was being instructed to tell the special counsel to end the existing investigation into the president and his campaign, with the special counsel being permitted to, quote, move forward with investigating election meddling for future elections. Mr. Dean, do you agree with that interpretation by the special counsel, and why?
Well, it's, I think what the special counsel is saying and what the president's asking for is to, as was said by former U.S. Attorney Vance, is an effort to end the investigation into present activity and to pretend like they would focus on future activities when there's no basis for that.
Mr. Dean, since the Nixon administration, have you witnessed any future administration commit more obstruction crimes than the Nixon administration? Yes or no?
No.
You would submit that, in your view, the Nixon administration, compared to every administration after, committed the most amount of obstruction crimes you've witnessed?
No. I gave a few samples in my written statement, and there are probably books will be written comparing these two.
Sorry, let me rephrase the question. Comparing Nixon to just any future administration, would you say there was a future administration that committed more crimes than the Nixon administration as far as obstruction?
I would say the Trump administration is in fast competition with what happened in the Nixon administration.
I would like to thank all of the witnesses for participating, especially Mr. Dean, Professor Vance, and Professor McQuaid. Your voices have been very important voices as our fragile democracy has been tested, and coming here today has laid out the foundation for our country as to what's at risk. You know, it's often said that history doesn't repeat, it rhymes, and we are hearing many of those rhymes today, and I would yield back.
Gentleman yields back. The gentleman from North Dakota, Mr. Armstrong.
Thank you, Mr. Chairman. We've heard several times today that we have to examine all of this in the totality of the circumstances, and I also would encourage everybody to read Volume 1. I'd encourage everybody to read the report. I'm on like my fourth time through it. I will admit I'm doing it by audiobook now. Well, I get to drive a lot in North Dakota, but I think how the witnesses, the tepidness to the answers regarding Volume 1 of the report speak volumes about where we're at in relation to this report. There's 22 months, 2 years, hundreds of hours investigated, and all started under the basis of collusion. We've read some tweets from some of our witnesses and those things, and we get to the point, and there is no collusion or conspiracy, which is the legal version of what collusion would be in this example. And I think that's important. Not a single member of the President Trump's family has been indicted. The indictments that actually came out of the Mueller investigation, with the exception of 25 Russians, which is purely symbolic because we're never going to get those indictments served, are unrelated financial crimes, tax fraud, campaign finance, lying to Congress, only once, not twice. We haven't brought Mr. Cohen in for the second time of lying to Congress yet. Identity theft, failure to register as a lobbyist, and conspiring to violate lobbying laws. And then several obstruction and lying to investigators, and I've read all of those lying to investigators charges as well. So I guess my question for Mr. Malcolm, when we are talking about dealing with this in the totality of the circumstances, how important is not having the underlying crime of conspiracy when we look at these obstruction charges?
Well, I certainly think it's a very important factor in terms of what would motivate the president to do what he did. He was being bedeviled by allegations that he knew to be false, and it was casting upon the legitimacy of his president and impeding his ability to govern. He had no problem looking into Russian interference in the election. I disagree, with all due respect to the characterization by Professor McQuaid about what he was asking Bob Mueller to do, but he clearly wanted Jim Comey to say that he wasn't involved in any kind of conspiracy or collusion, and he was frustrated by the ongoing cloud over his presidency.
And then just for a question, if Mr. Trump wanted to fire Bob Mueller, could he have President Trump fire Bob Mueller? Could he have done it at any time?
Sure.
If he wanted to fire Jeff Sessions, could he have fired him at any time?
Yep.
If he wanted to fire Bob McGahn, could he have fired him at any time?
Certainly could.
Okay. So, and as we're dealing with Endeavor, which Endeavor is really just attempt. I mean, it's endeavor to obstruct is the same as an attempted crime. Now, when we typically deal with attempt, we deal with it, and it's important that we have it, because if I determine I'm going to rob a bank or I'm going to murder somebody, there are underlying factors that could cause me to not complete that action. You would agree, right?
Yes. I mean, you have to look at what people do. You also have to consider what they say, but venting is venting, and this is a president who likes to vent. But you look at what he does, and in fact, he did not do any of the things that, he was talking about doing.
And then even more so when we walk through with the people who he was venting to, none of them, as far as the Mueller report is concerned, none of them really appeared to have any consequences as well, did they?
That is correct. Even people who knew that he was venting and didn't do what he asked them to do.
Now, and I just want to walk through, I would love to walk through actually one of the obstruction charges, but have you read Inspector Horowitz's Inspector General report as it related to the Clinton administration and the FBI?
In a while, but yes.
And you would agree that Mr. Horowitz found a ton of bias and impure acts, or at least thoughts. I mean, we have text messages, some of those are salacious, have made the news, conducted by the FBI agents, right?
Regrettably, he did.
But in his final conclusion, he basically asserted that because while there may have been a potential impure thought, there were also legitimate reasons for why they were conducting that action. So he didn't recommend any real true accountability to the FBI agents at that point, right?
Yeah, Inspector General Horowitz looked at the realm of reasonable decisions made by the investigators and prosecutors, and wherever possible, he gave them the benefit of the doubt. Sometimes he just couldn't because of the conduct involved.
And I guess that's just my overall general question. When you're dealing with some of these issues, if you have illegitimate reasons and legitimate reasons, and you have no underlying crime, how do you prove the intent?
Well, that is precisely the danger here, because you are talking about trying to determine what is an illegitimate or legitimate motive for core presidential discretionary actions. It's easy to do in the face of facially criminal conduct, such as paying a bribe or witness tampering or threatening a witness, but not with respect to the actions that the president undertook here, whether you like them or not.
And then I'll just end with, we've been talking about tweets that age well or don't age well. This is a tweet from our president on June 15th of 2017. They made up a phony collusion with the Russian story, found zero proof, so now they go for obstruction of justice on the phony story. Nice. So with that, I'll yield back.
Gentleman yields back. The gentleman from California, Mr. Liu.
Thank you, Mr. Chair. So let's talk about Jeff Sessions' recusal. As is well known, then Attorney General Jeff Sessions, following the advice of the Department of Justice ethics officials, recused himself on March 2nd, 2017 from investigations related to the 2016 presidential elections. Page 51 of the report goes on to detail a meeting between the president and the Attorney General, and it says, quote, that weekend, Sessions and McGahn flew to Mar-a-Lago to meet with the president. Sessions recalled that the president pulled him aside to speak to him alone and suggested that Sessions should unrecuse from the Russia investigation. Former prosecutor Joyce White-Vance, what do you make of that?
Recusal is not a question that the Justice Department considers infrequently. Recusal, conflict concerns come up in all sorts of situations. Maybe as a prosecutor, you knew someone personally, or your family owned stock in a bank, so you recused from that case. And when those situations come up, the prosecutor's obligation is to go to the office in the Justice Department that considers those concerns and gets advice. That's what Attorney General Sessions did. That was a dispositive conclusion that he had conflicts that meant that he could not be involved in any cases that were looking into the 2016 elections. So this request from the president that he revisit that, it's not just improper, it's incomprehensible. There is no such thing as unrecusal.
Thank you. Former Prosecutor McQuaid, you are also a U.S. attorney, is that correct?
Yes.
All right. Per the Department of Justice rules, is Attorney General or other personnel allowed to unilaterally unrecuse themselves?
No, there is no such thing as unrecusal. Think of it as he was tainted. A determination was made that he can be the Attorney General for many other cases, but not this one. Because of his political connections to President Trump, he correctly asked them to assess whether he could serve as Attorney General over this matter. They studied the matter and concluded that he could not, that he was tainted and he was unable to handle this case. And so to unrecuse oneself would be to ignore the taint and to commit an unethical act.
Thank you. Page 78 of Volume 2 of the report says, and I quote, "When Sessions told the president that a special counsel had been appointed, the president slumped back in his chair and said, 'Oh my God, this is terrible. This is the end of my presidency. I'm fucked.' The president became angry and lambasted the Attorney General for his decision to recuse from the investigation, stating, 'How could you let this happen, Jeff?' Sessions recalled that the president said to him, 'You are supposed to protect me,' or words to that effect." Mr. Dean, understanding what occurred during Watergate and in your experience, do you believe it is the role of the Attorney General to protect the president?
That certainly wasn't the case during the Nixon presidency. As a former employee of the Department of Justice, where I served as the Associate Deputy Attorney General, I know there's a proud and professional workforce at the Justice Department that doesn't do anything other than represent the American people. I don't think the Attorney General, his task is to represent the President. John Mitchell, who was the initial Attorney General, followed by Richard Kleindienst, and then former Senator Saxby and Elliot Richardson, I really don't think they looked upon their job is to represent Richard Nixon. So this is a sort of unprecedented view from Mr. Trump as to what the Attorney General should and should not be doing.
Thank you. Former U.S. Attorney McQuaid, what is your understanding of the role of the Attorney General?
The Attorney General is the lawyer for the people of the United States. He is to support and defend the Constitution, and he is to represent the people. He is not the personal attorney for the President.
Thank you. Page 107 of Volume 2 of the report documents some point after the May 17, 2017 appointment of the special counsel, Sessions recalled that the president called him at home and asked if Sessions would unrecuse himself. According to Sessions, the president asked him to reverse his recusal so that Sessions could direct the Department of Justice to investigate and prosecute Hillary Clinton. And the gist of the conversation was that the president wanted Sessions to unrecuse from all of it, including the special counsel's Russia investigation. Former U.S. Attorney McQuaid, what is your reaction to that phone call?
It demonstrates to me that President Trump was persistent in his efforts to get Attorney General Sessions to unrecuse himself because he was so desperate to limit the scope of the investigation. He was concerned about a number of things. I know that the congressman said if there's no underlying crime, then there's nothing to cover up, but I disagree with that. Number one, as a matter of law, that's not correct. But President Trump knew that there were a number of things that could be exposed about him. The payment of hush money that caused him to be named as individual one, as an unindicted co-conspirator in the Southern District of New York. The meeting at Trump Tower with Russians that, but for definitions of willfulness and thing of value, could have amounted to a crime. The conversations with WikiLeaks, all of those things, I believe, were matters that were our collusion and could have concerned President Trump about discovery and exposure.
Thank you. I yield back.
The gentleman yields back. The gentleman from Florida, Mr. Stubbe.
Thank you, Mr. Chairman. It's fascinating to me that the majority brings in Michael Cohen, a convicted liar who lied to Congress as a witness, and now the majority brings in Mr. Dean, who's convicted of obstructing justice and is paid by cable networks and others to opine against the president. So instead of legitimizing Mr. Dean's presence here today, I'll ask my questions to Mr. Malcolm. Mr. Malcolm, isn't it true that the president could have exerted executive privilege and prevented Mr. McGahn and others from cooperating with the special counsel.
Yes.
And in fact, not only did he encourage Mr. McGahn to cooperate, he allowed 20 White House officials to testify, including 8 people from the White House counsel's office.
Correct.
Isn't it true that the president has full constitutional authority without reason to fire the FBI director at any time?
Yes.
So how would it be obstruction to fire an FBI director?
I don't think it was. I would also point out that the report also indicates that others within the intelligence community and Attorney General Sessions himself had suggested that the president ought to do that before the president decided to do it.
Isn't it also true that if the special counsel had decided on the question of obstruction, he could have stated that there was evidence the president committed obstruction and recommended that he be charged with obstruction and not kick the decision to the AG?
He could have done that, yes.
And he could have recommended any form of charges that he wanted to recommend, including if he had found anything on Russian collusion or conspiracy or any of the matter.
While recognizing that it would not result in an indictment, he could have said the evidence was there to convict the president if he could be charged, yes.
Which he did not.
He did
and
not.
Kicked the decision to the Attorney General of the United States, who said, and I quote, "There's not sufficient evidence to establish that the president committed an obstruction of justice offense."
That's correct.
Could you walk me through, as an attorney who spent a number of years practicing in the courtroom and having numerous clients, could you walk me through the chilling effects that this is all having on future presidents having honest and open and frank conversations with their White House general counsel?
Presidents engage in, one, they solicit advice. Sometimes the advice that they're seeking is to do something stupid. Sometimes it may even be to do something illegal. That's why they have these conversations and get advice from trusted people. What this suggests is that by even having the conversation or saying something publicly or privately about it, one could be subjected to criminal liability. There are all sorts of actions that a president might take that might be aggressive, some of which are covered in the Mueller report with respect to appointing certain executive branch officials, firing certain executive branch officials, considering issuing certain pardons, engaging in executive orders, invoking the take care clause of the Constitution to actually involve oneself in an ongoing investigation if he thinks it's being unfairly conducted. All of those things can either be legitimate or illegitimate, depending on one's motives, and it would chill a president, I would think, to the bone to think that some prosecutor is going to be the person who is going to be making the determination about which action is legitimate, which is illegitimate, whether this was a mixed motive, a pure motive, or an improper motive. The mere fact that that inquiry could take place would have a chilling effect, which is why there is no clear statement that this obstruction of justice law should apply to the president, and which is why the independent counsel should have focused on facially illegal acts.
Well, you said it better than I could have said it. I just think that I don't care if you're a Republican or a Democrat. I think if you're going to be in the White House in the future, that all of this is going to weigh on whoever that president may or may not be in the decisions that he makes about having frank and open conversations with his counsel, who he should be able to have very private thought process. What do you think about this? In confidence, knowing that the White House General Counsel isn't going to be subpoenaed to testify about very conversations that they had about what is going on in the White House. And so I thank you for your testimony here today, and I will yield the remainder of my time to Mr. Jordan.
Mr. Malcolm, just let me go back to where we were a few minutes ago. In the Mueller report, it says, our report does not conclude that the president committed a crime. It also does not exonerate him. I'm trying to figure out how that squares with Title 28 of the Code of Federal Regulations impacting special counsels, where we read before, the Attorney General shall provide a confidential report explaining the prosecution or declination decisions.
Well, I don't think that it does, in addition to the fact that I don't think that it is any proper standard for any prosecutor to decide whether or not somebody has been exonerated. That's not the role of a prosecutor. It's not even the role of a jury. If a jury comes back and acquits somebody, it just says that they weren't found to be guilty beyond a reasonable doubt, not that they were factually innocent.
And it specifically says, when you read the section of Title 28, it specifically says the prosecution or declination decision reached by the special counsel. It doesn't say you don't have to decide at all. It says you got to pick one, and yet in his report he says our report does not conclude either way.
I read it the same way you do.
Okay. Now, why was he able to reach a decision though on one and not the other?
That you would have to ask him. He obviously felt comfortable with the state of the evidence. My guess is that his team was conflicted as to what to do, but that's reading tea leaves, and I don't read tea leaves very well.
All right. My time's expired. I thank the gentleman for yielding.
The gentleman yields back. The gentleman from Maryland, Mr. Raskin.
Thank you, Mr. Chairman. Mr. Dean, President Trump's National Security Advisor, Michael Flynn, pled guilty to making false statements to the FBI under 18 U.S.C. 1001 and has been cooperating with federal law enforcement investigators. He resigned on February 13th, 2017. Page 40 of the report documents an Oval Office meeting in the afternoon between the president and FBI Director Comey, where, and I quote, "The conversation turned to the topic of leaks of classified information, but the president returned to Michael Flynn, saying he is a good guy and he's been through a lot. The president stated, I hope you can see your way clear to letting this go, to letting Flynn go. He's a good guy. I hope you can let it go." Now, what do you think was taking place in that conversation?
Well, the only parallel I can draw in my mind to past presidents is what happened on June 23rd of 1972 when H.R. Haldeman came into the president to talk about the fact that people from his re-election committee were involved. And the president heard the chief of staff out and instructed him at the end of the conversation to have the CIA tell the FBI to stop its investigation.
Ms. McQuaid, what was your reaction to this exchange that I just quoted?
Similar to what Mr. Dean just said, and I think it goes to something that Mr. Malcolm has said as well, which is that, we can never allow prosecutors to second-guess the decisions of presidents. But I think that writes out of the Constitution the word faithfully, to faithfully execute the laws. Just as President Nixon was facing articles of impeachment for ordering the CIA to direct the FBI to stop investigating Watergate, similarly, President Trump's directive to let it go with Mr. Flynn was the same kind of corrupt act that is obstruction of justice. Even if he can't be charged criminally, this body has the ability to hold him accountable.
And indeed, when one of our colleagues says that it's up to the president to determine whether or not he faithfully executed the law, that's clearly wrong in a constitutional sense. It's up to Congress to determine whether the president faithfully executed the law. Isn't that right?
Of course. Otherwise, it would render invalid the checks and balances that are the hallmark of our system.
Thank you. Ms. Vance, what's your reaction to that scene where President Trump urged FBI Director Comey to drop the investigation against Michael Flynn and then ended up firing FBI Director Comey afterwards?
So, let me just be candid and tell you that I don't include that as one of the instances which I think qualifies for charging based on what we know at this point. The intent question is a little bit sticky. It's possible that the evidence there is there, perhaps it's not. But what it does tell us is a great deal about the president's state of mind and what he was focused on doing. And so there's this sequence of events where the president fires Director Comey, then goes on national television and acknowledges that he did it because Russia was on his mind, and finally has a conversation in the Oval Office with folks from Russia, with Russian government officials, where he tells them like he feels he's out from under the pressure of the investigation. So as we consider all of the circumstances that we're looking at in Volume 2, what's clear is that even at this early point in time, the president was focused on not letting this investigation move forward. And this really plays into this conversation that we've had a little bit about whether or not you have to have an underlying completed crime for obstruction. What's going on here is maybe there's a crime, maybe there isn't. The president doesn't know at this point in time, but he wants to shut down the investigation in case there is one. And that's why, under our criminal code, obstruction doesn't require an underlying crime.
Well, and isn't it the case that people get prosecuted for obstruction of justice even if they're not prosecuted for the underlying offense?
That's true, that happens, and there's also a case cited in the Mueller report that comes from my own district where a defendant was charged with 2 counts of obstruction but also with other crimes. On appeal, those underlying convictions didn't hold up, but the court let the obstruction convictions stand alone.
Mr. Dean, I want to come back to you for a moment. You and I are from different political parties. Indeed, you were the chief Republican counsel of this committee. You were the White House counsel for a president who put my father on his enemies list. My father was an official in the Kennedy administration and had a lot of problems with the Nixon administration. And So growing up, we were very fearful about the Nixon White House and what they would do to people. But you are clearly a man of honor and a man of integrity and a man who's standing up for the truth. And I wonder if you would just tell us why you have decided at this point in your career to come forward to talk about what is taking place in America and in the Trump White House.
Well, Congressman, I can remember when working for this committee back in the 60s, this committee did an awful lot of good things. For example, when I was here, there were amendments made to the 64 Civil Rights Act. There was the 65 Voting Rights Act. There was the 18-year-old vote. There was the 25th Amendment. A lot of activities, and it required both Republicans and Democrats to work together. This was a wonderful place to start a career in government, working for this committee. I'm not so sure today. There's too much polarization. You sense it in the questioning sitting here and the shots that get taken at witnesses. So what brought me forward was the invitation in this instance, where I thought, yes, I could share with particularly a lot of the people who were on this committee were either not born or they were very young when Watergate occurred. And it's quite striking and startling to me that history is repeating itself, and with a vengeance. So that's why I've spoken out.
Thank you very much. I yield back, Mr. Chairman.
The chair recognizes the gentlewoman from Arizona.
Thank you, Madam Chair. Mr. Malcolm, I'm first going to read some excerpts from the Mueller report and then ask you to comment on them, if you don't mind. Special counsel Robert Mueller is a prosecutor, and yet he did not recommend obstruction of justice charges against the president. And it has been said before by our ranking member Collins, there was a joint statement by the special counsel and Department of Justice that says the Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying that, but for the OLC opinion, he would have found the president obstructed justice. So let me again talk about some particular excerpts. And after reading the Mueller report, it was clear to me that Mueller knew that he may not have a clear case that could hold up in court. And in fact, he said, the evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. Namely, A, the president has Article II authority, and the acts the president engaged in are all exercises of the constitutional powers given to a president. B, second, there was no underlying crime. It would be almost impossible, I believe, to prove corrupt intent, which is required in the obstruction statutes. And Mueller himself said, unlike cases in which a subject engages in obstruction of justice to cover up a crime, the evidence we obtained did not establish that the president was involved in an underlying crime. He goes on to say, the absence of that evidence affects the analysis of the president's intent and requires consideration of other possible motives for his conduct. And then he further says, the term corruptly sets a demanding standard. Then C, Mueller report says many of the president's acts took place in public view. So with all those excerpts right from the Mueller report, in the words of Mueller himself, what do you think about my conclusion that he thought maybe this couldn't hold up in court, and that's why he didn't do the charges?
Well, I certainly agree that any prosecutor who would consider bringing an obstruction of justice charge would weigh heavily whether or not the person who was alleged to have attempted to obstruct justice had engaged in the underlying criminal activity under investigation. And in light of the fact that the president did not engage, or any of his campaign team engage in that activity, he had all sorts of legitimate reasons to be upset by this probe and what it was doing to his ability to govern. And so you can like the president's conduct or not like the president's conduct. I don't think anybody here likes what the president does all the time, that would probably be an understatement. But whether he had a legitimate beef that caused him to do what he did, goes to the issue of whether or not he had a corrupt intent.
Thank you, sir. My next question is for Ms. McQuaid. In a January 2nd Newsweek article, you said, "I think this case is far worse than Watergate." You said, "I think this case is far worse than Watergate because it didn't just involve a burglary to intercept communications of your rival. It included allegedly and potentially a conspiracy to collude with an adversary, Russia." Obviously, you were wrong that there was conspiracy or collusion with Russia. Do you admit to that?
I agree that Robert Mueller concluded that he could not establish the technical crime of conspiracy. However, I do think it was worse than Watergate. I think this president worked with Russia. The report says that the investigation identified numerous links between the Russian government and the Trump campaign. It also says that the investigation established that the Russian government perceived that it would benefit from a Trump presidency and worked to secure that outcome.
Because I only have 25 seconds left. Ms. Vance, on July 6, 2018, you tweeted, "Dangerous is the right word. The president is sowing hatred, fear, and distrust in hopes he can divide the country enough to survive when the truth comes out about his campaign's collusion with Russia." Well, the special counsel's team wasn't able to find collusion between the Trump campaign and Russia, but apparently you did. What is it that you knew that the special counsel didn't know and didn't conclude on after 22 months, 2,800 subpoenas, 500 bench warrants, 40 FBI officers, and multiple attorneys?
So Mueller in his report is careful to clarify that he's not making any decision about collusion. He's making a decision about whether or not he has evidence to indict the crime of conspiracy. A conspiracy is an agreement and an overt act in furtherance of that agreement, and Bob Mueller didn't find that there was evidence of that here. That is a far cry from saying that there was no evidence of collusion. There's abundant evidence of collusion in this record.
And, to me, it's clearly evident that each one of these Democrat witnesses that is before us today has had multiple previous statements publicly bashing the President of the United States, and it's really hard for me to take your testimony that it's not biased. Thank you. I'll yield back my time.
I recognize the gentlewoman from Washington.
Thank you, Madam Chair. Let me go now to the question of discouraging cooperation with federal law enforcement investigators by the President or his associates. The report documents multiple instances where associates of the President communicated with subjects or witnesses of the special counsel investigation and other investigations, potentially with the goal of discouraging cooperation. And as I go through these events, let me refer you to the displayed slide over here. On page 124 of Volume 2, the report begins to document public statements by Rudy Giuliani, the president's private attorney, relating to former Trump campaign chairman Paul Manafort. Quote, "Immediately following the revocation of Manafort's bail, the president's personal lawyer, Rudolph Giuliani, gave a series of interviews in which he raised the possibility of a pardon for Manafort. Giuliani told the New York Daily News that when the whole thing is over, things might get cleaned up with some presidential pardons." It continues on page 127 of Volume 2, quote, "Giuliani told journalists that the president really thinks Manafort has been horribly treated and that he and the president had discussed the political fallout if the president pardoned Manafort. The next day, Giuliani told the Washington Post that the president had asked his lawyers for advice on the possibility of a pardon for Manafort and other aides and had been counseled against considering a pardon until the investigation concluded." Mr. Dean, you had spoken about the question of presidential pardons in your opening statement. What is your reaction to Giuliani's statement?
Well, first of all, I've been waiting for his response to this report, which he promised had been drafted before it had been written, which has not been forthcoming. So we don't have any formal answer from him on these issues. But it's really quite surprising. He certainly knows the history of Watergate. He knows that Nixon got in trouble because of his dangling pardons. So this is pretty shocking material. but not surprising because we heard it publicly when it was occurring, and of course, the special counsel has included it.
And Professor Vance, as a former U.S. attorney, do you think public statements like that influence criminal defendants?
Obviously, they do. And, you know, the interesting thing here is that usually when, as a prosecutor, you're looking at an obstruction of justice case, it's not public statements, right? Obstruction usually happens under this cloak of darkness. You're trying to conceal it. But Mueller explicitly considers that and finds that public obstruction can still be obstruction. Everybody sort of shakes their head and wonders why you're doing it out in public. Maybe you think that if you're doing it in public, it's somehow okay, but it's not okay. And we see these statements and we see their impact, and we know that they do impact witnesses.
So let me continue. On page 127, the report says, quote, Giuliani was reported to have publicly said that Manafort remained in a joint defense agreement with the president following Manafort's guilty plea and agreement to cooperate, and that Manafort's attorneys regularly briefed the president's lawyers on the topics discussed and the information that Manafort had provided in interviews with the special counsel's office. On November 26, 2018, the special counsel's office disclosed in a public court filing that Manafort had breached his plea agreement by lying about multiple subjects. So, Ms. McQuaid, what is your reaction to the evidence that Manafort lied, but also was briefing the president's private legal defense team after agreeing to cooperate with federal investigators? Is that common practice for defendants? And why was that behavior, Manafort's behavior, so concerning to the court?
No, that is not common behavior. If you enter into a cooperation agreement, people sometimes even make the references, you've joined Team USA, you are going to cooperate, you're going to provide information to us, and the idea that you're taking information from the investigators, insights into their investigation, and sharing it with the defense, with the other side, is antithetical to a cooperation agreement. I can understand why at that moment they decided to tear up that agreement.
So on page 131, the report summarizes the evidence related to Paul Manafort. It says, with respect to Manafort, there is evidence that the president's actions had the potential to influence Manafort's decision whether to cooperate with the government. Page 132, evidence concerning the president's conduct towards Manafort indicates that the president intended to encourage Manafort to not cooperate with the government. Ms. McQuaid, do you agree, and why?
There is certainly evidence to support that. There are numerous tweets about being strong, not flipping. There were tweets about being a rat when you cooperate. And so looking at all of those things, it suggests that he was encouraging Paul Manafort to not cooperate with the government and continue to support him. And as someone who is so powerful, the president of the United States who holds the pardon power can deliver that message in a way that none of us otherwise can.
Thank you so much to all of you for your testimony, and I hope that the American people watching this understand how important this report is and how essential it is to actually read the whole thing from front to back. Thank you, Madam Chair. I yield back.
Gentlelady yields back. The gentleman from Louisiana, Mr. Johnson.
Thank you, Mr. Chairman. And Mr. Chairman, sincerely, I want to thank you for returning, so help me God, the phrase to the oath today of the witnesses. As we've discussed, that's an important tradition the American people want us to maintain. Let me ask a few questions, Mr. Dean. First, a housekeeping matter. When were you first contacted about testifying at this hearing?
I'm sorry, about this hearing?
Yes, sir.
Probably a couple of weeks ago. I was initially told it was planned for the 20th, and then later it had been moved to the 10th.
We're just curious. We only got exactly 7 days' notice, and we suspected this had been in the works for a while. On November 7, 2018, when Attorney General Sessions resigned, you went on CNN and you said, quote, "This seems to be planned like a murder. It's almost impossible not to interpret this any other way than a fact to undercut Mueller," unquote. Of course, now we know that didn't happen. The special counsel was allowed to finish his investigation, and the Attorney General or Deputy Attorney General never declined any requests made by the special counsel. So based on that statement, would you now admit that maybe you overstated the effect of the AG's resignation?
Well, what I was looking at was the fact that Mr. Whitaker was stepping in as an acting Attorney General, which was highly unusual, and that's why I made the comment I did. I think that when Mr. Whitaker got in there, he found the institution is much different than that of a U.S. Attorney's view of it, that there's a lot of spine inside the main Justice Department, and it was not something he could possibly carry out any assignments that he might have thought he could handle. So no, I wouldn't change my comment.
Okay. You also said in that same interview you believe Special Counsel Mueller had filed sealed indictments against the president's children and others that you said, quote, were high in the pecking order at the White House. But there weren't any such indictments.
Did I say they had been filed, or that was a potential, I believe is what I said?
I think you said they had been filed, but
Okay.
I'll give you that. That didn't happen, though, did it? Would
No,
you
it
admit you were wrong about that?
Well, my recollection being it was there was the potential of it. I'd have to look at the transcript of the broadcast you're talking about.
Mr. Malcolm, really appreciate you being here today. Your legal experience and your expertise on the matter before the committee have been very valuable to us. A couple questions for you. Many of the acts of alleged obstruction involve the president exercising his Article II authority that you've articulated very well today. Can you just explain the difficulty quickly in finding corrupt intent to obstruct justice when a president is carrying out those Article II powers?
Well, you have to be able to determine that it was done for an illegitimate purpose, that it was done to be purely self-serving and outside of the scope of the president's duties. And when a president is undertaking discretionary actions that are covered by Article II, which vests certain powers and duties in him, it is a very dangerous inquiry to go and look at and say, well, did he appoint this person because he's a crony? Did he appoint this person because he's going to do his bidding? Or did he appoint him on the merits? When he dismisses somebody, did he dismiss somebody because they were going to find some shenanigans that he was engaged in? Or did he dismiss him because he was incompetent? Or did he dismiss him for all sorts of other reasons? Anytime a president will be chilled at the thought that when he engages in these actions, a prosecutor, again, perhaps a politically motivated one, is going to be plumbing his mind to try to figure that stuff out. And, you know, it treads on separation of powers concerns that are quite real. When he's bribing somebody or illegally wiretapping somebody or threatening witnesses or suborning perjury, facially illegal acts, there is never a proper motive to do any of these things. But with respect to all of the things that I just talked about, and which are many of the things that Special Counsel Mueller looked at, they can be done for all kinds of motives, both proper and improper.
Very good. One more question. If this committee were to go to court to enforce the subpoena for the full unredacted Mueller report, at this point in the process, how do you think you would assess the merits of that lawsuit?
Well, at the moment, I believe that this committee would lose for the very simple reason that you are in the District of Columbia. The D.C. Circuit, in a case a couple of months ago, McKeever versus Barr, determined that there are no exceptions to 6E, Rule 6E, Federal Rule of Criminal Procedure 6E governs the exceptions in favor of disclosing grand jury material, and disclosures to Congress are not covered by that. This committee, and Congress can, of course, amend the law if it wants to, but at the moment, the governing law in this circuit, unless and until it is overturned, is that 6E material is governed by the exclusions there and nothing else.
Thank you very much. In spite of all that's been said here today and the countless interviews and the op-eds of our colleagues and all that, here's the one key fact we want everybody to remember. The White House and the Trump campaign provided unprecedented levels of cooperation with the special counsel's investigation. They produced over 1.4 million pages of documents to the special counsel. They allowed 20 White House officials to testify, including 8 people from the White House counsel's office. And in spite of all that, the Attorney General and former Deputy AG Rosenstein found the evidence developed by the special counsel was, quote, not sufficient to establish that the president committed an obstruction of justice offense, unquote. That should have ended the inquiry, but it hasn't. We're doing these political hearings, we're wasting the American people's time, and this committee has one of the broadest and most important jurisdictions of any committee in Congress. There is critical work we need to be doing, and we're not because we're mired in this. I'm out of time, and I yield back.
The gentleman is out of time. The gentlelady from Pennsylvania, Ms. Scanlon.
Thank you. Professor Vance, isn't it true that the president refused to answer any questions by the special counsel about obstruction of justice?
You know, he did, and I think that we should point out that written questions, written responses to prosecutors' questions, which is the only thing that the president provided to the special counsel, that's just a far cry from sitting down for an interview for all the obvious reasons. You can't have give and take. You can't follow up on an answer. Other presidents have submitted to these types of interviews. Bill Clinton certainly did. This president did not, and did not on the topic of obstruction.
Okay. We were discussing the president's actions to influence Paul Manafort, whether or not he would cooperate with the special counsel. The report in recent court filings document similar communications regarding Michael Flynn. and his cooperation with federal investigators. For those following along at home, the report on page 121 of Volume 2 says, quote, "In late November 2017, Flynn began to cooperate with this office. On November 22nd, Flynn withdrew from a joint defense agreement he had with the president. Flynn's counsel told the president's personal counsel and counsel for the White House that Flynn could no longer have confidential communications with the White House or the president. Later that night, the president's personal counsel left a voicemail for Flynn's counsel. Professor Vance, is it common practice for defense counsel to communicate in such a way with another defense counsel after a joint counsel agreement is no longer in effect?"
You know, I would actually hesitate to criticize attorneys communicating back and forth and trying to work out these circumstances. But this tape recording that we've now had the opportunity to hear is, to say the least, extremely unusual. And this, frankly, Congresswoman, is what one of the jobs that you all, I think, have the opportunity to complete as this conduct continues and as more evidence comes to light to determine whether there's any conduct here that constitutes a high crime or a misdemeanor. What did the president know? Was he involved in the placement of this call? Those questions still need to be answered.
The voicemail recording that you referenced was recently made public through court. But I'd like to read it here as printed on page 121 of the report, and I quote, "I understand your situation, but let me see if I can't state it in starker terms. It wouldn't surprise me if you made a deal with the government. If there's information that implicates the president, then we've got a national security issue. So, you know, we need some kind of heads up, just for the sake of protecting all our interests if we can. Remember what we've always said about the president and his feelings towards Flynn, and that still remains." Professor McQuaid, what's your reaction to the voicemail?
You know, there are two statements in there that jump out at me as at least inappropriate and very concerning. One is we need some kind of a heads up. If his premise is true, he assumes that Michael Flynn has now agreed to plead and cooperate. That means just the exchange we just talked about with Paul Manafort, that they want a heads up about what's going on. What are you doing? Are you cooperating? What are you telling them? What are they asking you? Which I believe would be inappropriate. And then the other part is where he says, remember, the president still has feelings toward Flynn, and that remains. I think that is a suggestion that, you know, we'll take care of you if you take care of us. And so I think viewing that alone does not amount to obstruction of justice, but I think when you look at it in other contexts, and perhaps you're getting to this, it's the return call when he calls him back and says, no, I can't do that. I can't provide you with information. And the response is, we take that as hostility from Mr. Flynn toward the president, and I'm going to tell the president, and he's not going to like that. That, coupled with what's in this message, I think does suggest a carrot and a stick about cooperation for Mr. Flynn.
So page 122 of Volume 2 does go on to say that Flynn's attorneys understood that statement to be an attempt to make them reconsider their position because the president's personal counsel believed Flynn would be disturbed to know that such a message would be conveyed to the president. Professor Vance, given the evidence presented in the report, do you agree with that assessment, and why?
I do agree with that assessment, and it's important to remember that we're not talking about just any individual here. We're talking about the President of the United States who's putting his thumb on the scale of the criminal justice system.
Finally, with respect to the president's former personal attorney and self-described fixer, Michael Cohen, on page 146 of Volume 2 of the report, they describe back-channel conversations between Cohen and Trump's private legal team, where they said, quote, on or about April 17th, 2018, Cohen began speaking with an attorney, Robert Costello, who had a close relationship with Rudy Giuliani, one of the president's personal lawyers. Costello told Cohen he had a back channel of communication to Giuliani, and the channel was crucial and must be maintained. The day after that, the New York Times published an article on Cohen and Trump's relationship. Page 146 of the report describes an email between Cohen and Costello. Quote, Costello wrote he had spoken with Giuliani. Costello told Cohen the conversation was very, very positive. You are loved. They're in our corner. Sleep well tonight. You have friends in high places. The report also notes on 146 to 47 that Trump tweeted his support for Cohen earlier that day. Professor McCabe, what's your reaction to these communications between Cohen, Costello, and Giuliani?
They are certainly a red flag. They would cause some concern for further inquiry that President Trump and his team are trying to coddle Michael Cohen, trying to encourage him to cooperate, talking about you're loved, you're in our corner, you have friends in high places. And the emphasis on high places is important because as the president, of course, he has the pardon power, which is the ultimate safeguard for Michael Cohen if he is to remain loyal to President Trump.
Thank you. I yield back.
Gentlelady yields back. The gentleman from Texas, Mr. Radcliffe.
Chairman, I wish I could say I appreciate you holding this hearing, but I can't because I don't. With due respect to some of the witnesses, some of whom have a background similar to mine at the Department of Justice, this has been just another in the latest of panicked, short-notice hearings where, despite Democrats telling us it's a vitally important hearing, in order to prepare for it, Republicans received the testimonies of the 3 Democratic witnesses an hour before the hearing started. Hearings featuring buckets of chicken and convicted felons, unfortunately, have become the norm for this once esteemed committee. So to any of my fellow Americans who are still tuned in, although I don't know why they would be, let me remind you how and why we're here today, why we're really here today. Hearings featuring buckets of chicken and convicted felons are being held by members of the Democratic Party that commissioned and paid for a dossier that falsely claimed that Donald Trump was part of a, quote, well-developed conspiracy, end quote, with Russia. That same dossier was used by a Democratic administration to justify an investigation into their own false conspiracy allegation. And now that the special counsel has conclusively and unequivocally found that there was no conspiracy between any American and the Russian government, much less a conspiracy that was well developed between Donald Trump and the Russians, well, those same Democrats who tried and failed to get rid of President Trump with a conspiracy that never existed, well, they are now undeterred. Now they want to justify their efforts to ultimately perhaps impeach Donald Trump by alleging that he obstructed their false conspiracy investigation. Now, even if we set aside whether it's even legally possible to obstruct an investigation that is not lawfully predicated, which this one may ultimately prove to be, and even if we set aside whether or not any president can obstruct justice by doing what the Constitution allows or authorizes a president to do, like fire any executive branch employee, even if we set all of that aside for now and focus instead on the fact that this obstruction of justice narrative against Donald Trump was started by the very same people who started the false conspiracy allegation. I'll remind my fellow Americans that it was Jim Comey who started the obstruction of justice theory in memos that he intentionally leaked, and some would submit unlawfully leaked, in order to start this special counsel investigation. And it was Andy McCabe and Peter Strzok and Lisa Page and Jim Baker who opened this obstruction of justice case after discussing the ridiculous theory, false theory, that Vladimir Putin may have ordered Donald Trump to fire Jim Comey. So now today, to advance that obstruction of justice investigation into an investigation where there was no conspiracy, my Democratic colleagues have called 3 witnesses. 2 of those witnesses were part of the Obama Justice Department when it started the false conspiracy allegation, to opine against the very same target of the false conspiracy investigation. And the third witness that the Democrats called is Mr. Dean. Now, Mr. Dean, I have no problem with you having an opinion. You've paid your debt to society, and you've made your opinion clear. In the last 2 years, did you know you've sent 970 tweets about Donald Trump? All 970 tweets about Donald Trump are anti-Donald Trump. So you are entitled to that opinion about him. You don't have to like him. But because of disbarment, you are legally prohibited from having an opinion about obstruction of justice. Look, to my Democratic colleagues, unlike Bob Mueller, who needed to find a crime to indict and did not, you don't need one to impeach Donald Trump. You don't need one. It's the same reason why the chairman, within days of Donald Trump getting elected, talked about impeaching him. It's why some Democrats on this committee voted to impeach Donald Trump just a few months after he was into office. It's why some Democrats on this committee voted to impeach Donald Trump before a word of the Mueller report was ever written. Look, you're in control of the House, and at the top of the House is a Speaker of the House who has reversed the presumption of innocence in this country to a presumption of guilt, and said last week that she plans to see Donald Trump in prison. So I don't know what your plans are. You all can do whatever you want, but stop wasting our time and just do it. I yield back.
The gentleman from Colorado, Mr. Neguse.
Mr. Chair, I believe the gentleman from Texas.
Excuse me. I'm sorry, I skipped the gentlelady from Texas, Ms. Garcia. I'm sorry.
You did not. You just called me. Great save. First of all, let me just thank Mr. Chairman, you for pulling this hearing together, to all the witnesses who have appeared. It's really important that we get some clarity on some of the issues around the Mueller report. And to do that, I want to go ahead and just follow up where our vice chair left off, Ms. Scanlon, and begin with you, Ms. Vance. Page 141 of Volume 2 of the report goes on to quote about Cohen, and we're dealing with, again, about Cohen. Cohen also recalls speaking with the president's personal counsel about pardons after the searches of his home and office had occurred, at a time when the media had reported that pardon discussions were occurring at the White House, end quote. And further, quote, according to Cohen, the president's personal counsel responded that Cohen should stay on message, that the investigation was a witch hunt, and that everything would be fine. Cohen understood, based on this conversation and previous conversations about pardons with the president's personal counsel, that as long as he stayed on message, he would be taken care of by the president, either through a pardon or through the investigation being shut down. Hearing that and seeing that in the report, and understanding Michael Cohen's circumstances, his long-standing relationship with the Trump family, and the evidence presented in the report, was Mr. Cohen's understanding of the situation reasonable, and why?
You know, ultimately that decision would be up to a jury or to a decision maker such as this body. But when you look at this evidence, it looks like the very heart of obstruction. If you take it out of the context of this president and his advisors, and think about other kinds of obstruction cases where you might see this kind of conduct. You think about, for instance, a drug trafficking ring, where the kingpin tells people, as long as you stay on our side, don't worry, we'll take care of you. This isn't an unusual situation, and we can plainly understand this language and what's going on here with Mr. Cohen.
Mr. Dean, do you have a reaction to that, sir?
No, I would join what Ms. Vance said.
Okay, and Ms. McQuaid, do you agree or do you see it any differently?
Yes, I agree. You know, I don't know that, again, looking at this in isolation gets us to a specific count of obstruction of justice, but looking at it in the grand scheme of things, it is part of a pattern of encouraging witnesses to cooperate and discouraging them, to protect Mr. Trump and discouraging them from cooperating with the government.
It's sort of a signal, huh? So now on page 141, again, of volume 2, the report goes on to say, quote, On August 21, 2018, Cohen pleaded guilty in the Southern District of New York to 8 felony charges, including 2 counts of campaign finance violations based on the payments he made during the final weeks of the campaign to women who said they had affairs with the president. During the plea hearing, Cohen stated that he had worked at the direction of the candidate in making those payments. The report notes that the same day, the president compared Cohen and Manafort, quote, and this is a direct quote, "I feel very badly for Paul Manafort and his wonderful family. Justice took a 12-year-old tax case, among other things, applied tremendous pressure on him, and unlike Michael Cohen, he refused to break up stories in order to get a deal. Such respect for a brave man." Then on page 150, then documents that Cohen pled guilty on November 29th to making false statements to Congress about the Trump Tower Moscow project. The same day, the report notes, quote, "The president also said that Cohen was a weak person, and by being weak, unlike other people that you watch, he is a weak person. And what he's trying to do is get a reduced sentence. So he's lying about a project that everybody knew about." And pages 48 through 152 document numerous other statements that the president has made about Cohen, either in public or through tweet. So my question to the three of you again, Mr. Dean, Ms. Vance, and Ms. McQuaid, what is your reaction to the evidence presented in the report relating to Michael Cohen and the possibility of a pardon? And Ms. Wade, you would like to start first?
Sure, I would agree with Professor McQuaid. I'm not confident that standing on its own, this conduct would support an independent charge of obstruction. We would need to look at it more closely and weigh it more carefully. But what it does do is it displays this pattern of conduct by the president. When you're on his side, he likes you. But the minute he thinks that you stray off of his team, he's quick to condemn you. And again, this isn't your boss or a neighborhood friend or someone like that. This is the President of the United States doing it formally and publicly in a way that conveys that he will protect you, perhaps even pardon you when you're on his team. But if you stray, you should expect consequences. It's not perhaps a count of obstruction, but it is obstructive conduct.
It's part of the pattern.
Absolutely.
Okay. Mr. Dean, anything you need to add?
Well, the pardon power is really one of the greatest powers a president is given in the Constitution. It's really unchecked and uncheckable. But if his motives are to guide a witness or influence a witness, the special counsel has a section in here on how a president misusing his powers is an indictable potential and not within the law. I don't think Michael Cohen is going to get a pardon given the current situation, given he did cooperate to a degree, not to the degree the Southern District wanted, but he did cooperate with the Southern District on the payment of hush money to 2 of Mr. Trump's mistresses just before the election. They, however, want cooperation from the day you were born until the moment you cooperate, which is a very high standard, higher than some U.S. attorneys' offices. So he didn't get the full support of the Southern District while he was an important witness, and a judge might give him some consideration at some point on that.
Thank you. And Mr. Chairman, McQuaid, did you have anything to add to that?
The only thing I would add is the fact that these statements were made out in the open. They were in public statements and in tweets. And what Robert Mueller says is, although that is uncommon, that does not in any way diminish their harm and could very well be the basis for an obstruction charge.
Thank you.
Time
Thank
of the gentlelady.
Yield back.
Time of the gentlelady has expired. The gentleman from Colorado, Mr. Neguse.
Thank you, Mr. Chairman, and thank you to the witnesses for your testimony today. I'd like to talk about 2 topics, the destruction of evidence and the interviews with the special counsel and the refusal to interview the special counsel. On page 10 of volume 1, the report states, and I'll quote, "Some of the individuals we, meaning the special counsel, interviewed or whose conduct we investigated, including some associated with the Trump campaign, deleted relevant communications or communicated during the relevant period using applications that feature encryption or that do not provide for long-term retention of data or communication records. end quote. The report discusses on page 130 of Volume 1 potentially destroyed evidence related to Manafort's communications with the Trump campaign members, the administration, and, quote, the peace plan and his meetings with Kilmenick. Page 10, Volume 1 goes on to say, quote, the special counsel's office cannot rule out the possibility that the unavailable information would shed additional light on or cast in a new light the events described in the report, end quote, which I believe both Professor McQuaid and Professor Vance alluded to in their opening statements. Professor Vance, what's your reaction to that statement in the special counsel's report, and how common is destruction of evidence in these types of investigations?
So it's a really good question, because I'll tell you what isn't common. What isn't common to see multiple sorts of incidents where evidence is destroyed or someone tries to get a witness to refrain from cooperating with an investigation. Typically, you see efforts to obstruct justice in isolation, or maybe you see one defendant doing a couple of things. This sort of systematic obstruction that's so extreme that the special counsel, when he writes his final report, feels the need to discuss it so early in the report, I think is unusual. And the full scope of what Mueller discusses here is witnesses who were unavailable because of privilege, witnesses who lied, as you point out, evidence that's destroyed by the use of technology and other apps, and information that's offshore. This is a persistent pattern, not an isolated occurrence.
Professor McQuaid, would you agree with that assessment?
I would, and we've heard today many representations about how President Trump permitted unprecedented access to his records, and yet Robert Mueller found no conspiracy. Robert Mueller puts very early in his report all of the obstacles that he faced, and even says that this gap means that more evidence could help shed some light on this matter. I think that supports hearings like this one to try to get to the bottom of what actually happened.
Well, so I want to speak to that, the misinformation, I think, in the public sphere around this quote-unquote unprecedented access that was given to the special counsel. As identified in the report on page C1 of Volume 2, quote, the president provided written responses through his personal counsel to questions submitted to him by the special counsel's office. However, page 13 of the volume states, quote, during the course of our discussions, the president did agree to answer written questions on certain Russia-related topics, and he provided us with answers. He did not similarly agree to provide written answers to questions on obstruction topics or questions on events during the transition. The special counsel's office also documented its effort to secure an interview with the president beginning in December of 2017. Still, on page C1, the report documents the office's discussions with the president's lawyers about a voluntary interview. I'll quote the report. We also advised counsel that an interview with the president is vital to our investigation. And, quote, the president's attorneys, quote, did not provide us with reason to forego seeking an interview. We additionally stated that it is in the interest of the presidency and the public for an interview to take place, and offered numerous accommodations to aid the president's preparation and avoid surprise. So, question, Professor Vance, what is your reaction to that passage of the special counsel's report, and of course, given your experiences as a prosecutor, the value in being able to interview witnesses?
Obviously, the experience that you have in the back and forth of questioning is much more productive for prosecutors. And the question that one's left with after reading this is, why wouldn't the president sit down and sit for an interview like other presidents had? If the explanation that we hear today, that there was so much cooperation from this administration, that witnesses were provided and documents were provided, and that this was a very cooperative effort by the White House to engage with the Mueller investigation, if all of that is true, then you have to ask yourself, why wouldn't they make the most important witness, the President of the United States, available?
Thank you, Professor. With that, I yield back my time, Mr. Chairman.
Thank you so much for those of you that are here today to testify. We greatly appreciate you taking the time, spending the time with us to get to the truth. I have some questions related to the disobeying of orders, and I refer you to the slides that we'll be discussing. President Trump has tweeted that nobody disobeys my orders.
And however, the report documents multiple instances where subordinates did the opposite. For example, on page 4 of volume 2, and I quote, on June 17, 2017, the president called McGahn at home and directed him to call the acting attorney general and say that the special counsel had conflicts of interest and must be removed. McGahn did not carry out this direction, however, deciding that he would resign rather than trigger what he regarded as a potential Saturday night massacre. Now, on page 5 of volume 2, and I quote, Lewandowski did not want to deliver the president's message personally, so he asked senior White House official Rick Dearborn to deliver it to Sessions, and Dearborn was uncomfortable with the task and did not follow through. Then on page 5, volume 2, and I quote, Lewandowski did not want to deliver the president's message personally, so he asked senior White House official Rick Dearborn to deliver it to Sessions. Dearborn was uncomfortable with the task and did not follow through. And the last example that I'll give you is on page 75, volume 2, which says substantial evidence indicates that the catalyst for the president's decision to fire Comey was Comey's unwillingness to publicly state that the president was not personally under investigation, despite the president's repeated requests that Comey make such an announcement. Mr. Dean, my question is for you. In your experience, is it common to disregard or to ignore direction or requests from the president? And in what circumstances would that be appropriate for staff to do?
It's unusual, but it did happen, for example, in the Nixon White House. Not every instruction generally given to either H.R. Haldeman, the chief of staff, or John Ehrlichman, the president's chief domestic advisor, when they thought the president was flying off the handle, sometimes they didn't act, but sometimes they did, or the president went to somebody who would. For example, at one point, Richard Nixon wanted to order a firebombing of the Brookings Institute so he could send burglars in to the safe when the fire department responded. Haldeman and Kissinger, who were present for that meeting, did not respond, did not pass the order. He called Chuck Colson in, another aide, and Chuck Colson did respond. When I got wind of it, I didn't know it was the president's order and heard this insane plan, flew to California and disrupted it and said it was insane. Ehrlichman picked up the phone, called Colson, and said, young counsel Dean is out here, doesn't think the Brookings plan's a very good one, and said, cancel it. And turned to me and said, anything else? I said, no, sir, I'll go back to Washington, which I did. So there's an instance where a president's plan to firebomb the Brookings Institute was canceled. But I can assure you, it's one of the early roots of Watergate because of the attitude it showed of what the president wanted.
Well, thank you. That sounds pretty disturbing, but I appreciate the truth. My questions are for all three of you. Mr. Dean, Professor Vance, and Professor McQuaid. What are your reactions to these kinds of decisions by the White House personnel to ignore the president? And Professor McQuaid, if you just answer first, please.
Well, on the one hand, I think anytime someone is disregarding an order from the president, we have a very dysfunctional White House that should alarm every American. On the other hand, I am grateful that they disregarded these orders because if President Trump had gotten his way, then the investigation into Russian attack on our election would have ended. It would have focused only on future elections, and we would not have the information that we have that's necessary to keep our country safe.
Thank you.
It's important to remember that this is a really good example. This is an explanation of why the statute that makes obstruction a crime also makes the attempt or the endeavor to commit obstruction a crime. Because even without the willing participation from his staff that would have permitted the president to complete his obstruction, this evidence still shows that the president's mindset was such that he wanted to take these acts, that he was not committed to truth in the criminal justice system, that he wanted to divert it away from the truth for his own benefit.
Thank you. Mr. Dean?
I agree that I think it's healthy at times the staff does not always follow through robotically and does interpret orders. But as I say, it is not the norm. It's typically when the staff senses something is terribly amiss and then they don't follow up.
Thank you. And I'm out of time. I yield the balance of my time.
The gentlelady yields back. The gentleman from Pennsylvania, Mr. Reschenthaler.
Thank you, Mr. Chairman. I yield to my colleague from Ohio.
The gentleman for yielding, Mr. Malcolm. I'm going to go back kind of where Mr. Armstrong and Mr. Stubbe were earlier this afternoon. Does the president have the right to fire people?
Yes.
Does the president have the right to pardon people?
Yes.
Could a lawful action like a pardon or firing an individual be done with corrupt intent and therefore be criminal?
It could be done for an improper purpose, again, but the president has plenary power to exercise a pardon.
Could a lawful action with corrupt intent be, could that be obstruction of justice?
Under certain circumstances with certain people, yes.
Okay, and could a lawful action with corrupt intent be criminal even if there is, in this situation, no underlying crime?
Sure.
Okay. But it seems to me, what if there's no action?
Well,
so I mean, I keep coming back to this. Did the president fire Bob Mueller?
No.
Did the president fire Rod Rosenstein?
No.
Did the president pardon Paul Manafort?
No.
Did he pardon Michael Flynn?
No.
Did he pardon Michael Cohen?
No.
Did he pardon Roger Stone?
No.
Did the president stop people from testifying?
Not so far as I know.
Did the president's chief of staff testify? Reince Priebus?
2 of them.
Yeah, 2 of them. Did the president's White House counsel, Don McGahn, testify?
Yes.
For 30 hours.
So I'm told.
Did the president do anything to stop Bob Mueller getting access to the information he sought access to?
Not that I'm aware of.
Did Jeff Sessions unrecuse himself?
No.
I don't know if that's a word, but it's been used a lot here today. No.
And I don't think there's anything improper in asking him to consider it.
Yeah, here's my point. When you, in my judgment, when you sum this all up, the president was falsely accused. Do you keep looking at something Bob Mueller chose not to indict, or do you investigate how the false accusation started? That's the fundamental choice for the House Judiciary Committee.
That's for this body to decide.
Oh, I understand. I'm not asking you a question. I'm making a point now. I'm actually directing my comments now to the chairman of the committee. I mean, Bob Mueller
The gentleman
chose...
yield for an answer?
When I got my 2 minutes and 43 seconds, maybe I'll let you answer. You get all the time you want because you run the committee. But when the president's falsely accused, Bob Mueller says he's not going to indict. The Attorney General of the United States says they're not going to prosecute, not going to indict. Do you keep looking at that? Or maybe do you want to look at how the whole darn thing started, how the whole false accusation began in the first place? Seems to me, particularly when we're talking about something as critical as the FISA court and the potential to violate people's fundamental liberties as could happen at the FISA court, and the evidence we already have seen, seems to me that's what you want to look at. But this committee says, nope, we're not going to do that. We're going to keep going and looking at something Bob Mueller and the Attorney General of the United States have already looked at. So I don't get it. I think the House Judiciary Committee should be focused on that fundamental question, but unfortunately, that's not where it's headed. With that, I would yield to the ranking member of the committee.
I appreciate the gentleman yielding. Mr. Dean, we may have actually found something we might agree on in your last statements. And it goes back to this whole idea that that some of the folks after Mr. Trump said that the president said stuff that they didn't follow through on. How many times, though, and I think following up on Mr. Jordan's comment, when you're in a position that you feel frustrated, there's a times when you had talked about the President Nixon, you related this back to Watergate, maybe the only analogy we take here. Your staff around you is supposed to either give that advice to not follow. They're there to help you. Your last statement, you gave indication of that. Would that be correct?
Yes.
Okay. Mr. Malcolm, in taking that step further, we're playing this as a bad thing that they didn't follow through, in going through this issue. But also, there are times wouldn't you also agree that there are times that that's what the staff is around you for, that you come up with, I mean, I come up with some, you probably have, the chairman I'm sure has, I have as well, came up with some bad ideas, and aren't you glad somebody's around you to say, or I'm just going to say, maybe he'll forget about it after lunch?
Yes, that's correct, particularly if you're familiar with the individual and are used to his venting his frustrations.
Exactly. I've got people who are very close, those are the ones you trust, and I think it's interesting here. It's also interesting as we continue this process to know that you're attributing bad motives simply because they should have done or not done, and it goes on in places of business all the time, in the law offices all the time, in the U.S. Attorney's offices all the time when this is looked at. So I think it's really interesting, Ms. Dean, coming back to that point you made. We may not agree on the end result, but I think the point made was something interesting. I'll let you finish. I mean, but going back to Ms. McQuaid for just a second, this is interesting that this is why this committee ought to be doing this. It's simply sitting here listening to people pontificate on the original of the Mueller report, which could be read and have different opinion, which we stated up front. That's not taking this a step further. This is simply regurgitating what has been your point of view for many years. Mr. Dean, I'll yield to you to finish.
I was just going to make the point, in your following up on Mr. Jordan, who has stepped out, if that were followed, Watergate would have never been investigated.
That's it. I yield back. I yield to the gentleman. We yield out.
Gentleman yields back. The gentlelady from Florida, Ms. McCarcel-Powell.
Thank you, Mr. Chairman. My colleagues have walked now through different actions by the President of the United States, and I'd like to talk through that pattern briefly. And if you'd like, I'll be referring you to the displayed slide. On the first row in that chart, pictures people who, according to the report, President Trump directed to deny facts. Can you give us your reactions to the President asking the three people in the first row to deny facts? I'll start with Professor McQuaid.
Looking at the pictures, I see what appears to be Donald Trump Jr. Is that Hope Hicks, maybe?
Yes, Hope Hicks
and Don McGahn. So I guess just to answer the question generally, denying facts suggests someone is being unhelpful in an investigation. We have heard some advocates here say President Trump was, an open book and sharing information, but that is not consistent with asking people to deny facts that are true, to deny what happened. With regard to Donald Trump Jr. and Hope Hicks, of course, it was rewriting the press statement about what happened at the Trump Tower meeting. That is a case that is perilously close to criminal behavior, meeting with a foreign adversary for assistance in the campaign. Robert Mueller concluded that that was not a crime because he was not able to establish willfulness, that is, knowledge that it was a crime, and that the material received was a thing of value, not that it didn't happen and it wasn't terribly unpatriotic. And so I think denying facts is certainly consistent with obstruction of justice.
Thank you. Now let's turn to the second row. According to notes written by former Attorney General Jeff Sessions' Chief of Staff, Joseph Hunt, when Sessions told the President that a special counsel had been appointed, the President, and I quote, slumped back in his chair and said, "Oh my God, this is terrible. This is the end of my presidency. I am," the F word, and I'm a mom. My kids are probably watching, which is why I don't want to say it. The report then documents attempts by the President to curtail the special counsel's investigation, which the report found, quote, linked to the special counsel's oversight of investigations that involved the President's conduct. That's volume 2, page 89. The second row in that chart pictures people who, according to the report, President Trump asked in some way to curtail the special counsel's investigation. Can you give us your reactions to the portions of the Mueller report which describe the President asking the people in row 2 to curtail the special counsel's investigation?
So I'm old enough that I'm going to flunk the eye chart exam here. But I'll talk about the incident with Attorney General Sessions, because this is well documented, and we know that what the President wanted to have the Attorney General do was to strictly limit the Mueller investigation so that it could only look forwards, so that it could not look backwards. And this means that the President of the United States wanted to make sure that there was no investigation into his own conduct, no investigation into the conduct of his associates, and no investigation into the conduct of Russia, which attacked our elections. This, I think, is dangerous territory for a president to be in. It certainly speaks in several of these events, particularly this one with former Attorney General Sessions and with Don McGahn, of obstructive conduct. It's certainly something that could be of interest to this body.
Thank you, Ms. Vance. Now, let's turn to row 3. The report states, quote, that many of the president's acts directed at witnesses included discouragement of cooperation with the government and suggestions of possible future pardons, and that the president engaged in conduct involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation. That's in volume 2, page 7. Row 3 shows people who, according to the report, President Trump encouraged not to cooperate with the special counsel's investigation. Can you give us your reactions to the portions of the Mueller report where the president contacted those witnesses? Either Ms. McCain.
That question to me?
Either.
I'm old enough that I've had cataract surgery and I can see the chart.
You can, that's great.
And I did address that in my opening statement, the fact that pardons were dangled throughout and may still be the case that they're being dangled. There's no question that's an obstruction as far as the Congress is concerned. It was paragraph 9 of Article 1 of the Nixon impeachment proceeding. So this body has set the precedent as far as their view of presidential conduct that it is improper.
Thank you, Mr. Dean. I yield back my time.
The gentlelady yields back. The gentlelady from Texas, Ms. Escobar.
Thank you, Mr. Chairman, and thanks to all of you for being here. As we near the end of this hearing, I want to quickly walk through a few of the significant findings by the special counsel, just to summarize for the record. And while I have them on a slide, I will be reading the words on the slide for you. On page 89, volume 2, it states, quote, substantial evidence indicates that by June 17, 2017, the president knew his conduct was under investigation by a federal prosecutor who could present any evidence of federal crimes to a grand jury. Professor Vance, quickly, do you agree, based on your understanding of the events and the evidence presented in the report, and if so, why?
Well, I do, and this is the nexus question, right? We're talking about whether the president is aware that his acts would interfere with ongoing investigations. And it's clear that as these acts take place, he had that awareness and that that element of the offense of obstruction could be established for several of these instances.
Thank you. Page 89, volume 2, quote, substantial evidence indicates that the president's attempts to remove the special counsel were linked to the special counsel's oversight of investigations that involved the president's conduct, and most immediately to reports that the president was being investigated for potential obstruction of justice. Mr. Dean, do you agree, based on your understanding of the events and the evidence presented in the report, and if so, quickly, why?
Well, I think it's pretty obvious that it's spelled out nicely by the special counsel in this report, that indeed he's making the case that that is obstruction of justice.
Thank you. Page 120, volume 2, quote, substantial evidence indicates that in repeatedly urging McGahn to dispute that he was ordered to have the special counsel terminated, the president acted for the purpose of influencing McGahn's account in order to deflect or prevent further scrutiny of the president's conduct toward the investigation. Professor McQuaid, do you agree, based on your understanding of the events and the evidence presented in the report? And if so, quickly, why?
Yes, I believe this is the strongest example of obstruction of justice. This even goes beyond exercise of the president's Article 2 powers by directing McGahn to create a false document. I believe Mr. Malcolm and Mr. Barr even would agree that this is obstruction of justice.
Thank you. Page 97, volume 2, quote, substantial evidence indicates that the president's effort to have Sessions limit the scope of the special counsel's investigation to future election interference was intended to prevent further investigative scrutiny of the president's and his campaign's conduct. Professor Vance, do you agree, based on your understanding of the events and the evidence presented in the report, and if so, why?
So this, again, would ultimately be a fact question for a jury. But based on the evidence that we have in front of us in the report, I think a prosecutor could appropriately indict and expect to convict on the basis of this evidence.
Thank you. Professor McQuaid, you've reminded us throughout this hearing that we need to look at all of this evidence in its totality. What does all of this evidence in its totality tell you?
Number one, that Russia attacked our country. Number two, that President Trump sought to curtail the investigation of that attack because he was concerned that some of his own behavior might amount to criminal behavior. It might delegitimize his electoral victory, or it might expose criminal behavior of paying hush money. As a result, he committed at least 4 acts of obstruction of justice. Robert Mueller could not charge him. Out of an abundance of fairness, he didn't even want to say he could charge him because he left it to Congress for impeachment.
Thank you. As I'm sure you are all aware, the president recently declared that he is, quote, fighting all subpoenas issued by Congress and has directed all of his senior officials, including his former counsel, Don McGahn, not to testify. Recent polls show that nearly 3/4 of registered voters believe these officials should obey congressional subpoenas and testify. Mr. Dean, as a former White House counsel, how should congressional subpoenas be handled by the executive branch?
There's no question they must be honored in some way. There is a May 20th of this year, the Office of Legal Counsel issued a memo that White House staff and close advisors of the president, both sitting and former, are immune from subpoenas of this body. This is an extreme view to me. And I must add something to put the bigger picture together. Having watched Office of Legal Counsel, when I was in the White House, it was considered to be the president's law firm. That's always been the case. And the president's law firm tends to give favorable decisions to their client. And this is true from everything about not indicting a sitting president to making current staff totally immune from Congress. I think these all need to be tested in court because I don't think most of them will stand.
Thank you. Yield back.
Time of the gentlelady has expired. The gentlelady from Florida, Ms. Demings.
Thank you so much, Mr. Chairman, and thank you to all of our witnesses for being with us today, for your endurance and your testimony. I'd like to talk a bit about the special counsel and the OLC opinion. Professor McQuaid, there has been some confusion related to Special Counsel Mueller's final determinations in the report. As a matter of background, I want to address the Department of Justice guidelines that were governing his work. In Volume 2, pages 1 through 2, the report states, and I quote, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognizes that a criminal investigation during the president's term is permissible. The OLC opinion also recognizes that a president does not have immunity after he leaves office, and if individuals other than the president committed an obstruction offense, they may be prosecuted at that time. As a former federal prosecutor, do you believe the special counsel was confined by the OLC opinion?
Yes, I believe that he found that he could not reach a traditional prosecutorial decision with regard to charging a sitting president, and so he sought to preserve the evidence, as he said, while memories were fresh and documents available.
Thank you. Professor Vance, on page 2 of Volume 2, the report continues, and I quote, given those considerations, the facts known to us and the strong public interest in safeguarding the integrity of the criminal justice system, we conducted a thorough factual investigation in order to preserve the evidence when memories are fresh and documentarial materials were available. Given the restrictions placed on the department, why was it appropriate for the special counsel to conduct a thorough factual investigation in order to preserve the evidence?
The best time to conduct a criminal investigation, as the Mueller report notes, is as close in time as possible to the events taking place. That's when people's memories are freshest, when documents are available. And so Mueller in the report acknowledges that although the OLC memo kept him from indicting a sitting president, that there were a number of other legitimate purposes for investigation. The president would not be immune from charges forever. There could be other people involved. And as the OLC memo explicitly notes, even though a president can't be indicted, he can be impeached in Congress. OLC almost seems to contemplate impeachment as the appropriate step to take for the one person in our society who's immune from prosecution.
So you're saying even in the
temporarily.
OLC opinion, that is the inference or the...
They explicitly say that the president can be impeached.
Thank you. And Mr. Dean, on page 76 of Volume 2, the report states, and I quote, "The evidence does indicate that a thorough FBI investigation would uncover facts about the campaign and the president personally that the president could have understood to be crimes or that would give rise to personal and political concerns." What is your reaction to that statement by the special counsel's office? Do you agree, and if so, why?
I'm sorry, my phone was ringing in my ear during part of your statement. Could you recapture it for me?
On page 76 of Volume 2, the report states, and I quote, "The evidence does indicate that a thorough FBI investigation would uncover facts about the campaign and the president personally, and that the president could have understood to be crimes or that would give rise to personal and political concerns." What is your reaction to that statement by the special counsel's office? Do you agree, and if so, why?
I think the special counsel has shown throughout this report that he's been very cautious and prudent in what he has said and what he has not said. This is in the tradition not of the Ken Starr independent counsel investigation, but rather in the roadmap that was referred to this committee that was skeletal and just a minimum of facts, and clear facts based on the investigations, grand jury hearings, FBI interviews. So I think this is a very appropriate statement and very insightful.
Thank you so much, and Professor McQuaid, back to you. The report then goes on to state, and again, I am quoting directly from the report on page 2 of Volume 2, "At the same time, if we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we were unable to reach that judgment. Accordingly, while the report does not conclude that the president committed a crime, it also does not exonerate him." What is your reaction to that statement in the special counsel's report?
I believe that because Robert Mueller could not make a charging decision, he did not want to prejudge the evidence because he was leaving it for Congress. He did not want to preempt Congress's power of impeachment and wanted to leave that consideration open. It has been pointed out today that some have said prosecutors don't exonerate, they charge or don't charge. That's only true in a traditional case. We talk about the binary decision, but that can't be the case when you're dealing with the president who cannot be charged. Otherwise, that is a heads you win, heads I win, tails you lose. And so in that scenario, Robert Mueller simply put the evidence out there and he left it for Congress to decide whether impeachment was appropriate.
And I think someone mentioned earlier that he almost went above and beyond to make sure of that, his decision in that.
Yes, I think out of an abundance of fairness, he didn't even want to say that a crime had been committed because he did not want to prejudge the evidence for another decision maker, that is Congress.
Thank you all so much, Mr. Chairman. I yield back.
Gentlelady yields back. The gentleman from California, Mr. Correa.
Thank you very much, Mr. Chairman. First, I want to thank all of the witnesses for being here today. This is very important. I think we're making history again in this United States of America. And Mr. Dean, I also want to thank you very much because, as was said earlier, you paid your debt to society, yet you still came up and you've taken some shots, so to speak, personal shots here, but yet you still wanted to be here and testify. Why did you decide to show up and testify?
Congressman, when I worked for Mr. Nixon, I was really never worried about what the outcome would be and how it would be resolved. I've got to tell you that from the day Mr. Trump was nominated, and I was following in a separate set of polls, the Los Angeles Times as well as the Monmouth polls, and it looked pretty clear to these pollsters that Mr. Trump had a very good chance of winning. And I began developing a knot in my stomach that sits there to this day. So I'm trying to deal with that in the best way I can to try to tell people these are troubled times, and we should go through these processes and sort them out. So anything I can do to add to the process, I'm more than willing.
Thank you very much. I'm going to turn to the firing of FBI Director James Comey. Early 2017, the White House was warned that National Security Advisor Michael Flynn was being investigated after lying to federal authorities about communications with the Russian ambassador about sanctions on Russia for its election interference during the campaign. Mr. Flynn's false statements constituted a federal crime. On page 31 of Volume 2 of the report, it describes the initial warnings from the Justice Department, and I quote, open quote, "The public statements made by Vice President denying that Flynn and Kilshek discussed sanctions were not true and put Flynn in a potentially compromising position because the Russians would know he had lied." Yates disclosed that Flynn had been interviewed by the FBI. And as we know, Flynn later pleaded guilty to making false statements to the FBI and has been cooperating with federal law enforcement investigators. My question for Ms. Vance and Ms. McQuaid, as former federal prosecutors, can you explain the value of charging someone with lying to federal prosecutors?
That's how we protect the integrity of the system. If people feel free to lie when they're being questioned by people who are in law enforcement, the entire system breaks down. It's in some ways a self-accountability system, and a question of whether we want to have a lawless society or a society that's governed by the rule of law. Every federal prosecutor I know takes that crime very seriously.
Ms. McQuaid?
I would agree. False statements is a brand of obstruction of justice. It's a crime. Some people have criticized it as a process crime. Crimes are among the most important there are. They're very serious because it prevents investigators from finding the truth.
Charging him with lying, does that mean that the FBI didn't have anything else to charge him with other than lying?
No, it doesn't, actually. Charging 18 U.S. Code 1001, which is lying to the Bureau, and of course there are variants of that, lying to Congress, obstructing justice. These are charges that mean that we take the system seriously. Sometimes they're brought alone, sometimes they're brought in tandem with other charges. But one issue I'd point out, Congressman, that seems to be lost in the conversation is that if we don't charge obstruction without an underlying crime, that means that the people who are the best obstructors, the most successful people at hiding their crimes, those people would get off scot-free. That's not how we want this system to work.
Mr. Dean, you mentioned that the firing of former FBI Director James Comey, you saw some parallels, my words, what happened during the Nixon administration. Brought back some memories. Can you elaborate a little bit on what your thoughts there were?
Yeah, the firing to me, well, many things in the report are reminiscent of Watergate and their parallels. The firing of Comey was not unlike the June 23rd effort by the President Nixon to halt the FBI investigation, which is what he did. He tried to use the CIA to stop the investigation by having his chief of staff meet with the director of the CIA and invoke this. And this was based on information that had come from his former attorney general, who is his campaign manager. And initially, there might have been a legitimate reason to do this because they were still trying to figure out what the CIA's role was. But as you listen to the tapes and it goes through each step, Mr. Nixon escalates it from what the real reason was to this being a solution of a way to stop the investigation. So it was the decision of hearing that tape is what resulted in this committee, where there were 11 Republicans who disagreed with Article 1, turning around and, while the vote had already been taken, joining the majority and saying, if this comes to a vote on the floor, because of this tape, we think it is so troublesome that we will join the majority and vote for Article 1, which was the obstruction article.
So your opinion would be continue these investigations?
Absolutely.
The time of the gentleman has expired. The gentlelady from Texas for unanimous consent request.
I thank you, Mr. Chairman. I'd like to put into the record the framework for this hearing, and that is a report on the investigation into Russian interference in the 2016 presidential election, which includes Volume 1 and 2.
Without objection.
And to thank Mr. Dean, Ms. Vance, Mr. Malcolm, and McQuaid for their commitment to this hearing, Mr. Chairman, and to remind us that Barbara Jordan said we must uphold the Constitution. I yield back.
Without objection, the report will be entered into the record. The gentleman from Arizona, Mr. Stanton, is recognized.
Thank you very much, Mr. Chairman. I want to thank the witnesses for being here today and to offer their testimony on what has become one of the most important responsibilities of our time. That's defending our Constitution and the rule of law. And you being here today has been critically important to help explain to the American people what's in the Mueller report and to provide important context and analysis, and I thank you. I had a question for Professor Vance and McQuaid. I wanted the opportunity to kind of respond to a general argument that Mr. Malcolm has made throughout this hearing. I believe that Mr. Malcolm has suggested that the president should only be investigated for facially illegal exercises of his Article 2 power, such as granting a pardon in exchange for bribes, that the conduct investigated by the special counsel should be beyond the scope of a criminal inquiry, because otherwise the threat of criminal prosecution would act as a chilling effect on the presidency. I want each of the opportunity to respond to that argument and give us your thoughts on it. Please, how about Professor McQuaid first?
I disagree with that argument, and so did Robert Mueller and his team, who rejected that argument. Now, there are some instances of obstruction of justice in the report that are facially destructive, asking a witness to create a false document, that are even beyond Article 2 powers. But even within Article 2 powers, the phrase that Robert Mueller hung his hat on was the word faithfully in the Constitution, that the president has a duty not just to execute the powers, but to execute them faithfully, and to permit him to execute his executive powers without any check on it would render him above the law.
Professor Joyce, your thoughts on that, on Professor Malcolm's general argument throughout the hearing today?
So I think it's a strained interpretation of the law, and I categorically reject this suggestion that under the Constitution and under our laws, there is one person in this country who's above the law, the President of the United States. I don't think that's what our system does. And here's a good example. If people struggle with that issue, it's not a president, but it's the executive of the state of Illinois, the Governor Rod Blagojevich, who did an act that he was entitled to do. He appointed a senator to replace a senator who had vacated his seat. And that's a perfectly legal act. The problem was he took a bribe in exchange for agreeing who he would select. Lawful act, corrupt motive, that's corruption of justice, and it should be for a president too.
Mr. Dean, you had a very brief answer.
Yes, I want to footnote that I've studied virtually all the presidencies since Nixon, including Nixon's, and presidents operate usually very well with investigations going on. They compartmentalize, they function, they have no problem with it. If they're innocent, it passes away. If they're not, then they have some problems. But they still operate well when investigations are going on.
Professor Vance, I'm sure you're familiar with the federal statute regarding witness tampering, 18 U.S.C. 1512. There are some who believe that witness tampering can't happen in light of day or by use of social media, that it could only be done outside of public view. I wanted to get your thoughts on that theory.
So, you know, I'm going to confess that it's surprising to see witness tampering happening in plain view and on Twitter. I don't think that that's something that a lot of prosecutors have confronted before this. But legally, there is no reason that that public conduct can't be obstruction. And we know, because we've seen it, that it can have that effect. It is, I will say, very unusual to put the evidence out there for the FBI to collect.
Let me pose a quick hypothetical maybe for Professor McQuaid. If you were investigating the actions of a high-profile individual, maybe someone of immense power, political power, and that target publicly praised witnesses who refuse to cooperate with the government as having, quote, guts, unquote, could that be evidence of a violation of federal witness tampering statutes?
Yes, I would say that would be some evidence. I might want more evidence, but it would certainly be a red flag to me that would cause me to want to investigate further.
How about if that same powerful figure publicly suggests that law enforcement agencies under his control should, quote, watch, unquote, members of a cooperating witness's family?
Mr. Chairman.
Could that be
Point of
evidence?
order.
Gentleman will state his point of order.
I will just ask that the gentleman rephrase his question. Otherwise, I will continue my point of order. If the gentleman will agree, I will withdraw my point of order.
Well, I was only asking in the hypothetical.
It doesn't matter. You cannot do that according to the parliamentary rules of this House.
Gentleman may wish to rephrase his question.
He's given a.
I think the point was made, and I will yield back. Thank you.
The gentleman yields back. I want to observe before we close that several members have said that this committee should not be investigating a bogus allegation against the president, but should rather investigate the origins of the bogus investigation. I would point out that the report from the special prosecutor makes very clear that the Russians attacked our elections, that they did so intending to help the Trump campaign, that there is substantial evidence that the Trump campaign knew about the Russian attack, that it welcomed the help of the Russian government, that some Trump campaign officials cooperated with the Russians, that there is, I would observe, there is clear evidence of collusion, though not enough evidence to prove criminal conspiracy beyond a reasonable doubt, collusion being defined as cooperation. This is not a bogus investigation of a false allegation, but a very necessary investigation of a threat to our country and our liberty. And this committee and this Congress have an absolute obligation to the American people to investigate this. Before we close, I ask unanimous consent to insert into the record a copy of each of the slides referenced at the hearings. Without objection, they will be entered. I ask further unanimous consent to enter a letter signed by over 1,000 federal prosecutors in both Democratic and Republican administrations stating their views on the Mueller report. Without objection, that will be entered into the record. This concludes today's hearing. I want to thank the witnesses for attending, for their patience, their fortitude, and their fortitude with some of the questions or statements. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. And without objection, the hearing is adjourned.